My name is Bernard Koku Avle. I am a radio and television journalist, and my job is to call people's names to speak and to thank them for speaking. So very simple. This program is divided in two parts. We have a few introductory remarks, then we have the lecture, after which we would have a panel discussion stroke Q&A program. We're streaming some of this, so please be happy, all right? Smile, because we're live in certain places. We're not going to put your information where it's not necessary, but please be happy. Having had the cue to start, I'd like to go through the procedure, and then we'll move straight into the program. Okay, so from the Kempinski Hotel, Gold Coast City, this is the fourth in the series of Kojo Bentsi Enchill Memorial Lectures. Thank you very much indeed. These lectures have been instituted by Bentsi Enchill, Ace Ankomah, Ghana's leading law firm, in memory of the legal luminary and legend Kojo Bentsi Enchill. We're grateful to have our audience here at the hotel, plus our many viewers online, join us for this very special edition of the program, which is on navigating international commercial disputes, Africa's experience. We have a fantastic panel to discuss a very eye-opening presentation by one of Africa's leading legal practitioners, and we'll be telling you more about that as the program proceeds. To set us off, though, it is my distinct pleasure to welcome our managing partner, Seth Asante, who would bring up the chairman to set the ball rolling. Ladies and gentlemen, please help me welcome our managing partner, Seth Asante. I would like the applause to continue until he gets here.
Good afternoon, everyone. You're all welcome. Distinguished invited guests, Justices of the Superior Court, if there are any here yet, we're expecting some. The Honorable Attorney General and Minister for Justice, senior members of the bar and colleagues at the bar, family of the late Kojo Bentsi Enchill, partners and staff of Bentsi Enchill, Ace Ankomah. Ladies and gentlemen, good afternoon and welcome to the fourth Kojo Bentsi Enchill Memorial Lecture. Thank you for joining us to honor the memory of our co-founder, colleague, mentor, and friend. We're grateful to Kojo's family for being with us this afternoon and for the continuous support you give to this lecture series. Your presence at these lectures series affirms the value of rigorous thought and professional excellence which Kojo championed throughout his life. This year marked the 35th anniversary of Bentsi Enchill, Ace Ankomah. It is a milestone. Thank you. It is a milestone we do not take for granted. The enduring growth and success of the firm is a tribute to the standards and principles set at its founding and the commitment of generations of distinguished colleagues who have carried the vision forward. Today's lecture is part of that commitment, which includes the need to always reflect on issues of national and international importance. We are delighted to have Mrs. Funke Adekoya, SAN, as our guest speaker, supported by a distinguished panel of experts to address the theme, Navigating International Commercial Disputes, Africa's Experience. This subject could not be more relevant as Africa deepens its engagement with global commerce. Disputes that cross borders are inevitable. The real test is how such disputes are resolved fairly, credibly, and in ways that strengthen confidence in our institutions. I am certain that today's lecture will explore these challenges and highlight the opportunities for African governments and legal practitioners to shape Africa's involvement in international dispute resolution. I extend the firm's deep gratitude to the Honorable Attorney General for joining us and for agreeing to deliver the opening remarks. Thank you. The Honorable Attorney General, apart from being an old vandal, which is more distinguished than anything else he has done in his life, is a distinguished alumnus of the firm and part of our rich tapestry. And I think we should clap for that as well. We look forward to a discussion that is intellectually fulfilling, practical in insight, and a fitting honor to Kojo's legacy. I wish to thank our planning team, partners, and staff whose tireless work has made this event possible. It is now my privilege to introduce the chairman of the occasion, Mr. Divine Lecha. We call him DKD. Mr. Lecha is a retired founding partner of the firm and one I affectionately refer to as the firm's godfather. His leadership and mentorship have been central to the firm's development and to the growth of many practitioners in this firm. Please give a clap to Mr. Lecha. Ladies and gentlemen, please join me in welcoming Mr. Divine Lecha as the chairman for this occasion. Thank you very much.
Thank you, ladies and gentlemen, for accepting our invitation to come to this fourth memorial lecture. It affords us the opportunity to meet as friends, as former pupils, and also to share thoughts and ideas, to fraternize with each other as we wait for the next year. Now, somebody asked, "You are still chairman?" I said yes, but until further notice. And I think you understand when I say until further notice. Now, coming to the topic, navigating international commercial disputes in Africa, Africa's experience. Now, for as long as Ghana and Africa, for that matter, remains or continues to operate within the global trade and commercial system, we will always have differences for partners. Some of these differences can become full-blown disputes. For example, trade disputes on tariffs. And when I mention tariffs, I think you know what I mean. Subsidies and other trade practices, which we on this side refer to as unfair trade practices. We also would have investor and state disputes, conflicts between foreign investors and host states. Traditional dispute resolution mechanisms such as out-and-out litigation through the courts have proved unsatisfactory in resolving international commercial disputes. As alternatives, we have employed diplomacy, arbitration, and other ADR mechanisms like mediation, conciliation, negotiation, all with varying degrees of success. In Ghana, we realized very early that there will be need for ADR. At least soon after independence, we enacted Arbitration Act 1961 to enable us deal with investment disputes as they may arise from our very rapid economic development. And we wanted to do it by a way other than litigation. Major transactions like the Volta River Dam Construction Development Agreement had arbitration clauses, and so did other subsidiary agreements that were offshoots of that main transaction. Now, similar legislation exists in African countries. But moving further, international institutions like the ICC, the AAA, that's the American Association of Arbitrators, the LCIA, the London Court of International Arbitration, the ICC, incidentally, is the International Chamber for Commerce, have all developed courts and centers for procedural rules that regulate arbitration proceedings. In Africa, we can mention OHADA, for example, that has mechanics for this kind of thing. But mainly, 17 Francophone countries subscribe to it. We have the SADC, that's for the Southern African Development countries, backed by the AFSA, the Arbitration Foundation of South Africa. Now we can also mention the Ghana Arbitration Center. Additionally, there are projects all over Africa going on for the harmonization of laws and procedures for arbitral processes all over Africa. Now, ADR has been touted to be faster, cheaper, and more flexible compared to traditional litigation. For example, flexibility involves the ability of the parties to choose for themselves their judges. However, we are also faced with the implication as to whether the assertion that is more efficient, less antagonistic, and confidential has been played out to our satisfaction. The question that arises for us as African practitioners and beneficiaries of ADR on the international level is how have these lofty ideals played out for us? We hear undercurrents and ripples that tell us that, after all, ADR is not as cheap or as fast or as efficient or as flexible as have been touted. It seems we are still finding our feet in the courts of arbitration. African partners and parties often feel trapped by their own arbitration clauses on which they rely to prosecute their claims. More than that, they even feel ambushed by the rules and procedures that traditional foreign arbitration courts have evolved. Coming to the topic, I pick the word navigating. Navigating suggests to me that it is not on calm waters or calm seas that commercial disputes are resolved. The higher the stakes, the rougher and tougher the process, and our opponents are not in for charity. They demand their pound of flesh. In the circumstances, we have to navigate not only with skill, but with seaworthy equipment. Now, lately, legal issues for ADR have become more complex, moving away from the normal breach of contract issues. Now, issues like pollution. To prove pollution demands solid scientific evidence. Are we in a position to provide it? If we compare our ability to find solid scientific basis for pollution with the resources and endowments that our opponents have, getting the evidence as solid as we want it to be, to me, is daunting. Also, we have issues like failures to commit to net zero operations, for example, in the mining industry. We also have the environmental, social, and governmental issues that plague us. Then we have digital trade, the global online trading system, and the threats of cyber attack. Are we ready? There are cross-border data flows and privacy concerns. So it's no longer the ordinary infringement of trademark, copyright, or patents. It's going deeper than that. Are we ready? Now, the new monster, the AI. How ready are we? Are we able to regulate it? Are we able to use it and to defend or to make claims in that respect in our investment agreements? I'll leave the guest speaker and the panel of discussants to give us an assessment of how far we are fared in the ADR space, and whatever suggestions they have for us as to what we can do better going forward. I hope I'll resume my seat and get back to you with my closing remarks. Thank you.
Thank you. We're grateful to you, sir. Please put your hands together one more time for Mr. Divine Lecha. Still on setting the scene, we'd like to now hear from a family rep in the person of the Reverend Stella Bentsi Enchill. Let's welcome her with a round of applause. Quick journalistic point, she is one of the first 3 women deacons ordained as priests of the Anglican Church in Ghana some 14 years ago. Congratulations. Thank you.
Good afternoon. May I, on behalf of the family, thank you, partners, chairman, and all in the firm of Bentsi Enchill, and Ankomah, for introducing and continuing with the Kojo Bentsi Enchill Memorial Lectures. My thanks go also to Mrs. Mercy Bentsi Enchill and family for asking me to represent them. I am touched. Kojo Bentsi Enchill, or as he was called in the family, Nana Bentsi, because he was named after his paternal grandfather, was destined for great things from his childhood. And I say this as someone who has known him from his infancy in the early 1950s, when the family lived in a house called Mary Villas in Accra Central, on a road now known as Asafwache Nete Road. This was at a time when most lawyers lived in Accra Central, with their chambers close by. And so now Ferg Chambers, which was started by Professor Bentsi Enchill, was located in that area. At the demonstration school of the University of Ghana, he stood out as an exceptional and gifted pupil. Although he was really, really tiny, now everyone thinks of Kojo as this tall guy, but he was a very small child. And so, because of his exceptional gifts, he was permitted to sit the common entrance early. And so he entered Achimota School at the tender age of 10. This was at the time, 1960, when many of the entrants at that famous school were usually aged 13, if not 14. And so he stood out, and no doubt was bullied for being different. Kojo was exceptional in every way. At Achimota, because of his grasp, even at that early age, of the English language, for his intellect and maturity, the teachers often selected him for roles that most of his peers could not even dream of. And so came that day, on his very first year in Achimota, when he was chosen, a Nino boy, for the poetry competition and won it. The poem was The Lamb by the 18th century poet of the Romance era, William Blake. But the humor and assurance with which Kojo delivered the lines of the poem captivated the entire audience, and so he won the competition. Small boy danger, as we called him, winning against all odds. It is interesting that in his English boarding school, he also won another prize for poetry reading and subsequently became the head boy of that school, a first at that time in the 1960s. Kojo Bentsi Enchill was truly an icon and one whom all the Bentsi Enchill family held in high esteem, not only for his intellect, but for his integrity, his compassion, and good sense. When his father, the late Professor Bentsi Enchill, died unexpectedly in 1974, although Kojo was a mere 24 years old at the time, he took on seriously the responsibility of being a protector and mentor for his younger siblings, and also a great support for their mother, Mrs. Wilhelmina Bentsi Enchill. And later we were lucky because he extended his mentorship and support to many of the younger cousins, even aunties, from both the paternal and maternal sides of his family. He always exhibited the best sense in the advice he gave to the younger ones, and they welcomed his interest in their welfare and the guidance he generously proffered. The younger ones were so proud of their connection to him and relished their relationship to the person they came to know as an accomplished lawyer in our community. So proud of him were they that when my own son Kofi had his first child, a boy born on Monday and so to be named Kojo like any good Fanti boy, I suggested that the child might be named Nana Bentsi after their common ancestor and great-grandfather. My son's response was to turn down my suggestion flatly, saying that the name Nana Bentsi should not be given to anyone else and should be reserved for this icon, an extraordinary man whom we all respected and loved. That was the level of respect that he was accorded in the family. From the oldest member, Auntie Rachel Phillips, his cousin, to even the youngest and not so reverent members. I recall on his death one nephew stating that Uncle Nana was my moral compass, my anchor in a storm. Another family member said that Uncle Nana was not only a great professional, but also a wonderful human being. And still another said of him that he was principled, always obliging, very thoughtful, and in all ways, an admirable man. What memories, what a legacy. It is often said that acquiring money and position is good, but more important and lasting is the way that people experience you, remember you, your interaction with them, and how you made them feel. Our family experienced Nana Bentsi well. Our lives were affected by the many acts of kindness, support, love, guidance that he freely gave to us. And we were bereft at his departure and the void that his death created in our lives. One of the memories of Kojo which really touched us, though, was at his funeral, when so many of the lawyers he had helped train at Bella mounted up in their numbers on the stage during the reading of the tribute by the firm. It was so moving and showed the impact that KBE's life had been on the lives and careers of so many people, so many young lawyers. A lawyer's lawyer, mentor, coach, visionary, challenger, an exemplar who in just 70 years left an indelible footprint in the sands of time. What memories, what a legacy. And so as we congratulate Bella on 35 years of its existence, we thank you once again. With such a life well lived, we can only echo the words of St. Paul in 2 Timothy. Kojo fought the good fight. He finished the race. All that remains is for the Lord to crown him with a promised crown of righteousness. Sleep well. KB, you'll forever be in our hearts. Thank you.
I hear it. Oh, beautiful.
Oh, come on. Wow. Wow. I need to find your diocese and come and listen to a Sunday sermon. I thought that was beautiful. Poetic, precise, really nice. Let's applaud him one more time for that. And I'm sure he'll be smiling from heaven. Yeah, God bless you. All right, so we now want to get into the presentation, but we're very privileged to have the Attorney General and Minister of Justice for the Republic of Ghana, who is also a member of Parliament. And, you know, I had planned an elaborate introduction for him, but Seth spoiled the whole thing by simply saying he was a vandal. I mean, it didn't matter that he went to Notre Dame, Tamale, University of Ghana, Michigan, Stanford. I mean, to just drop this vandal thing, you know. But the truth is that since our president is also a vandal, and by the way, if you're not from Ghana, it's not an insult. I noticed the principal speaker looking at me strange. Vandal is an acronym for students of hall in the University of Ghana. And they have a very interesting acronym. He will explain it. V for vivacious, A for annoying, N for something, D for something. So the president is a vandal, his foreign minister is a vandal, his education minister is a vandal, his attorney general is a vandal. So we're all going to become vandals at this point. So maybe next cabinet meeting, they'll hold that part and sing that song. Anyway, so it's good to have him. When I got in, he was the first person sat here with Oliver. Tells you he's very determined to be here. He's not going to give a full speech. He's just going to give some remarks, give us some context, endorse the program, and then we'll bring up stage our lecturer. So ladies and gentlemen, please help me welcome the Honorable Dr. Dominic Akurutinga Akurutinga Ayine. Thank you, sir.
Our distinguished speaker, Mrs. Funke Adekoya, I hope I got that right. Distinguished invited guests, justices of the Superior Court of Judicature, the managing partner and staff of Bentsi Enchill Lecture in Ankomah, family members of Kojo Bentsi Enchill, colleagues, ladies and gentlemen. I deem it a great honor to join you today, this afternoon, for the 4th Bentsi Enchill Memorial Lecture. And I mean this from the bottom of my heart. When Kojo Bentsi Enchill, whom we affectionately called KBE, signed my letter of appointment in 1996, admitting me to practice as an associate of the firm, then known as Bentsi Enchill Lecture and Mate, I could not then have imagined that I would one day be bestowed with the honor of giving the opening speech at a lecture in his honor. So, I wish to thank the partners of the firm for conferring this immense honor on me, and to commend you for introducing and sustaining this important forum of reflection. Our common mentor, teacher, and boss will continue to live not only through the name of the firm, but more importantly, through these lectures, which I hope are designed to reflect his values, principles, and worldview. Permit me also to recognize the presence of members of his family. We thank you for sharing him with us and with the legal profession as a whole. And to Mrs. Bentsi Enchill, Mrs. KBE, if I may call you so, I wish to let you know that your extempore obituary during his burial service was the best I've ever heard at any funeral. And I'm sure on that day, KBE was brimming with smiles from above. On a personal note, ladies and gentlemen, today's event stirs up deep memories. As a young associate at Bentsi Enchill Lecture in Ankomah,
I had the privilege of working under Kojo's watchful eye. He was not only a brilliant lawyer, but also a meticulous teacher. And when I sat over there with Ace Ankomah, who was then a senior associate when I was there, I didn't know that that was Kojo staring at me. Until much later when the image became clearer and I told him that I remember this look very well. Anytime you sat in front of him, with your work, and Kojo stared at you that way, it means there were issues with the draft. He demanded discipline and intellectual rigor in every assignment. Kojo explained that the role of a lawyer was not to impress, but to communicate with precision. That lesson stayed with me, and I have carried it through every stage of my career. Kojo was that kind of mentor, demanding, exacting, but always deeply invested in the growth of his juniors. Now, if you want to know how exacting he was, I'm sure those of us who worked with him will tell you. So my experience was, I'm just going to give you one example. If I have to give many experiences, we will not end today. But I remember distinctly we were in that small Osu office where the firm started. And then I took a draft to him. At that time, there were no computers. You would write by hand. Mavis will type it. Mavis was the secretary. She will type it. Then you take your draft to Kojo for endorsement. So I wrote a legal opinion, took the draft to him. He corrected it. I took it back to Mavis. She retyped it. I took it back to Kojo. He corrected his own corrections. I didn't say anything. So I took it back to Mavis. Mavis typed the corrections. I took it back to Kojo. He corrected his own corrections for a third time. So I said, sir, you are correcting what you corrected the second time. This is the third time. He said, Dominic, can't you understand I'm trying to get it perfect? That was the kind of teacher he was. So his passing was a great loss to Ghana's legal fraternity, yet his legacy endures. He believed the practice of law should be more than just a profession. He observed that the law should be a tool for national development. He built a culture of excellence at the firm, one that shaped generations of lawyers and placed Ghana firmly on the map of serious commercial law practice. Many of the lawyers he trained have gone on to take key leadership positions, advise on landmark transactions, advise governments, and shape our national institutions. His influence continues to ripple through the profession and the nation at large. This year also marks the 35th anniversary of Bentsi Enchill lecture in Ankomah. That milestone is itself a living monument to Kojo's vision. From its early days, the firm has grown into a respected law practice and a reflection of Kojo's dedication to excellence. What makes this anniversary significant is not just longevity, but the fact that the firm has remained faithful to the values Kojo instilled in all of us. For that, both the legal profession and the wider society owe him and his colleagues a debt of gratitude. Ladies and gentlemen, at a time when Ghana continues to refine its legal and institutional framework to meet the demands of a fast-changing global economy, Kojo's convictions remain as relevant as ever. He insisted that legal structures must be strong, transparent, and fair if they are to serve as engines of development. His vision resonates with our ongoing efforts to strengthen the rule of law, improve the climate for investment, and ensure justice for our people. This lecture series, established in his honor, has quickly become a respected platform for dialogue. Each lecture has addressed topical issues including corporate insolvency, investment in natural and other resources, and the evolution of monetary policy. This year, the focus turns to another critical frontier, international commercial disputes, or the international commercial dispute resolution. The theme, Navigating International Commercial Disputes, Africa's Experience, is both timely and compelling. As African economies deepen their integration into global markets, cross-border disputes are no longer the exception, but the norm. Therefore, how we resolve these disputes will determine investor confidence and enhance the credibility of the continent's various legal systems. Too often, African disputes are exported to foreign jurisdictions for arbitration. This is not merely a question of venue. It speaks to trust, expertise, and institutional strength. We must ask the question, how can Africa build systems that command the confidence of global commerce whilst reflecting our own values and practices? Our distinguished speaker today, Mrs. Funke Adekoya, SAN, that is Senior Advocate of Nigeria, is eminently qualified to lead us through this discussion. She has been at the forefront of commercial arbitration and dispute resolution, both within Africa and on the international stage. Her insights, together with those of the eminent panel assembled, will hopefully challenge us to think boldly about Africa's place in the global commercial dispute context. This is not just a matter for lawyers. It is a matter for governments, businesses, and citizens. Poorly managed commercial and investment disputes can cripple economies, destroy partnerships, and erode public trust. Disputes well managed, on the other hand, can reinforce the rule of law, attract investment, and secure justice. Today's lecture offers us an opportunity to reflect on how Africa can shift from being a consumer of international legal norms and legal services to a producer of solutions that others respect and adopt. As we gather in KBE's memory, let us remember what he stood for: discipline, clarity of thought, fairness, and the belief that law must serve society first. If he were here today, he would urge us to be courageous in thought and uncompromising in principle. Kojo was resolute in his belief that every case, every transaction, and every reform is part of a larger effort to build a just and prosperous society. May this lecture honor his life and works, and also inspire us to advance the frontiers of legal thought and practice in Ghana and across Africa. Once again, I thank Bentsi Enchill Lecturer in Ankomah and all the partners who have sustained this noble tradition, and I thank you all for your attention. May we have a fruitful and engaging event. Thank you, and God bless all of you.
I thought I was brilliant. Please, put your hands together for him. Wow. I think he liked the way I introduced him, so he left his phone here as a gift for me. So I will come for the password. to leave your phone with a journalist, a pesky journalist on air. What a treasure. God bless you. All right. It's now time to introduce our speaker. And some lawyers said to me, it's better to structure things in numbers. So I have just 7 quick things to read. Permit me to do this. Not because she needs it read, but because her life story will inspire the young generations as well. So our speaker is Mrs. Funke Adekoya son, an independent arbitrator and litigation consultant, having retired from her role as partner at Alex, a Lagos, Nigeria-based law firm, which she co-founded in 2004. After being called to Nigerian bar in 1975, she earned an NLM from the Harvard Law School in 1977. She's a fellow of the Chartered Institute of Arbitrators, a chartered arbitrator, and a fellow of the Institute of Construction Industry Arbitrators in Nigeria. So that's 1. 2, she's been actively practicing law since her call to the bar, accumulating 50 years of experience in commercial litigation, and dispute resolution, and regularly appearing before all the courts of record in Nigeria. She's also provided expert witness statements and opinions on issues in Nigerian law for use in courts in Turkey, the United States of America, Italy, and the United Kingdom. In this role, she's had to engage with their court system and procedures. 3. In 2001, she was elevated to the rank of Senior Advocate of Nigeria, SAN for short. The Ghanaian version will be SAG. The name doesn't work, so it didn't succeed. What Brew didn't agree. Okay. The name is not even correct, SAG. I mean, how can you go SAG? You know, SAN is nice. So this is the Nigerian equivalent of the King's Council in the United Kingdom, becoming the 5th woman to be elevated in that capacity. She thereafter, qualified as a solicitor in England and Wales in 2004, where she currently holds a non-practicing license. 4. In November 2020, she concluded a 6-year term as a member of the World Bank Group Sanctions Board, which is the final decision maker in contested cases arising out of allegations of fraud, corruption, and collusion in World Bank Group finance development operations. She currently sits on the Sanctions Appeals Board of the African Development Bank. 5. As an arbitrator, she's participated in high-value commercial and investor state arbitration proceedings under the LCIA, ICC, and ICSID arbitration rules, in addition to ad hoc arbitration proceedings administered by the PCA under the UNCITRAL rules. In this role, she's been appointed as either a co-arbitrator or a presiding arbitrator in disputes involving both African and non-African parties. 6. She's been a vice president of the ICC Court of Arbitration, a vice president of ICA, the International Council for Commercial Arbitration, and a member of its governing board. Upon concluding her term in April this year, she was elected to its advisory board. And 7, she currently sits on the courts of the Singapore International Arbitration Center and the Abu Dhabi International Arbitration Center. Ladies and gentlemen, the 4th edition of the Bentsi Enchill Memorial Lectures is happy to give to you our speaker, Mrs. Funke Adekoya. Please put your hands together.
Get it. If I could finish.
Members of the KBE family, both extended and nuclear, members of the firm, distinguished colleagues, ladies and gentlemen, I'm honored and privileged to have been invited today to share my thoughts with you on navigating international commercial disputes, Africa's experience. I start by saying that the views that I express are my perception of what Africa's experience has been from the point of view of a player, either as arbitration counsel or as arbitrator. And it is my hope that the panel will then interrogate some of the things and the positions that I have put forward. Perhaps my perception of Africa's experience can be challenged. What has been said by earlier speakers, international commercial disputes rely on international trade, because disputes are always a consequence of international relationships. So any discussion of Africa's experience must be set against the background of international trade on the continent. So permit me to start with a few figures and statistics. Because in this context, investment figures can stand as a crystal ball, indicating trends in global investment flows and the disputes that may then emerge from that sector. It is unquestionable that African countries are net capital importing nations, relying on foreign funds to boost their economic output.
So what is the context in which we should consider Africa's experience in the international commercial disputes arena? According to the UNCTAD Investment Trades Monitor for 2024, FDI, foreign direct investment inflows to Africa, amounted to approximately $50 billion United States dollars during the year, and that represented a 23% increase over previous years. It's notable that although investment in renewable energy slowed globally in 2024, Africa actually experienced growth in this sector, with an 8% rise compared to previous years, unlike the declines seen in other regions. So clearly this means that other parts of the world are getting their renewable energy problem sorted. Nigeria still is an investment destination for this. Will there be disputes coming from this sector? I would say watch that space. But where these disputes occur, international arbitration remains the preferred method of resolution. And this is supported by the correlation between strong arbitration frameworks within reliable legal systems and their positive impact on FDI in African countries, as potential investors feel reassured by the legal regime overseeing their investments. In this context, African states are taking proactive steps to boost foreign direct investment inflows into their countries by sorting out their legal frameworks. For example, Angola signed new BITs, bilateral investment treaties, with China and Japan in 2024. So you can see where they are hoping that foreign direct inflows will come from. And these BITs include international arbitration clauses to provide better legal protection and stronger enforcement mechanisms for Chinese and Japanese investors in Angola, where investors from both countries are not only investing in the oil, gas, and natural resources sectors, but are also increasingly involved in construction, technology, and even professional services. Similarly, Ghana and Trinidad and Tobago concluded a BIT on the 24th of September, 2024. Meanwhile, in February of this year, Eswatini, a small South African country, or small country in Southern Africa, and the UAE, United Arab Emirates, as well as Japan and Zambia, signed BITs, bilateral investment treaties. However, none of these BITs have yet come into force. The recent uptick in BITs signed between African states and FDI exporting countries, to my mind, reflects Africa's effort to reassure potential investors that any investments they make within their home countries are safe. Over the past decade, several African states have also enacted or revised their arbitration laws to align with international best practices, most particularly the ancestral modern law on international commercial arbitration. And all this is done in an effort to boost confidence in their domestic legal terrain for international disputes. Let's start the African journey from home. Arbitration in Ghana is now regulated by the Alternative Dispute Resolution Act 2010, Act 798, which substantially reflects the provisions of the ancestral modern law. I must note, however, that the ancestral modern law has itself been updated in 2017, and therefore perhaps the Ghanaian legislature needs to have another look at its own arbitration law to further bring it up to date. South Africa has enacted an International Arbitration Act in 2017, which incorporates the principles of the ancestral modern law with specific modifications, such as an enhanced provision on security for costs and interim relief. We earlier had mention of OHADA, the Organization for the Harmonization of Business Law in Africa. And OHADA covers most Francophone countries in West Africa and some even in Central Africa. And OHADA has also revised its Uniform Arbitration Act in 2017. And those reforms were heavily inspired by the ancestral model law. Tanzania's arbitration law is primarily governed by its Arbitration Act 2020. And that act provides a comprehensive framework for conducting arbitrations, including the appointment of arbitrators, the conduct of proceedings, and the enforcement of awards. Most recently, in 2022, Sierra Leone enacted a new arbitration law. The previous act, I think, was 1950. The Arbitration Act modernizes Sierra Leone's arbitration framework, replacing previous legislation, which was based on the English Arbitration Act of 1950, and seeks to align Sierra Leone's arbitration practices with current international standards. Nigeria also enacted its Arbitration and Mediation Act in 2023, which fully incorporates the ancestral modern law and modernizes arbitration practice by introducing provisions for the appointment of emergency arbitrators, interim measures, arbitrators' immunity, and provisions on third-party funding. Malawi has proposed to enact an International Arbitration Act in 2023, which closely follows the ancestral model law and also thereby seeks to modernize the country's arbitration framework. Although Uganda slightly amended its own Arbitration and Conciliation Act in 2024 in relation to its government arbitral institutions, a detailed study is currently being conducted to address potential gaps in the Act, while identifying international best practices and proposing necessary reforms. So clearly, so many African countries are taking steps to provide what it can push forward as a modern, conducive arbitration framework that fits in with international arbitration policies. Even though Uganda has not yet concluded its reform of its Arbitration Act, it has actually enacted in February this year a national ADR policy. That policy aims to popularize ADR mechanisms such as negotiation, mediation, arbitration, conciliation, and collaborative law in an effort to reduce the overwhelming case backlogs in the Ugandan judiciary. Nigeria has done the same by also enacting a national ADR policy, directing state and federal governments on procedures involving the appointment of arbitrators, the resolution of disputes, providing for a framework for how arbitrators should be appointed in disputes that involve state or federal agencies, and also keeping a record of arbitrations that involve state or federal entities. So we can see that many African countries are looking to ensure that their arbitration frameworks are fit for purpose, all in an effort to ensure that when the commercial disputes that result from the inward investment they are hoping to attract, when those disputes arise, that their legal frameworks will be considered as the basis for resolving those disputes. What has been Africa's experience, however, in negotiating these international commercial disputes to date? A SWOT analysis, strengths, weaknesses, opportunities, and threats. SWOT analysis of Africa's engagement over the past decade reveals that one consequence of increased investment in Africa is the rise in disputes related to those investments. I refer to some research which was conducted by an organization called the Transnational Institute, which is a non-governmental think tank. Between 2013 and 2019, it found that African governments faced more investment claims than the total number of claims in the previous 20 years, with the total known investment treaty claims against African governments reaching 106 by January 2019. That was 6 years ago. In fact, as of January 2019, when they published their report, 28 out of 55 African states have been sued by investors before international arbitral tribunals, with cases against Algeria, Egypt, and Libya accounting for nearly 50% of the total number. And note the Arab Spring that affected Egypt, affected Algeria, affected Libya. So where there's war and there's conflict, there's a likelihood that investor disputes may be part of the results. Now let's turn to more recent statistics. Statistics obtained from the LCIA, London Court of International Arbitration, in their annual case report for 2024 indicates that the percentage of African parties involved in LCIA arbitrations more than doubled in 2024, rising from 8% in 2023 to 17%, with Kenya and Nigeria being the top two countries. Similarly, the ICC also noticed an increase in the number of African parties in cases involved and filed with them in 2024 when compared with 2023. It's also undeniable that Africa is actively involved in investor-state disputes. Of the 54 countries in Africa, as at 2024, 41 have experienced ICSID arbitrations, which amounts to 75% of the continent's nations. There have been some recent statistics that came out just last week from ICSID, which has reported that 25% of the cases filed at ICSID this year, that's between January and June, 25% of the cases, 1/4, are cases that came out of Africa. So you can see the increase. Many of them from what we call the Sahelian states, Niger, Mali, Burkina Faso. You know what's happening in those countries. With the rise in disputes and the growing use of international commercial arbitration in Africa and by African states, the continent has seen the establishment of several arbitration centers, as well as increased collaboration between Africa-based institutions and international arbitral bodies. By way of example, the Arbitration Foundation of Southern Africa, AFSA, and the Lagos Chamber of Commerce International Arbitration Center, LACIAC, have signed cooperation agreements with the Permanent Court of Arbitration in The Hague. Furthermore, the AFSA International recently became a member of the International Federation of Commercial Arbitration Institutions, which includes organizations such as the London Court of International Arbitration and the ICC's International Court of Arbitration. All these relationships are to provide local arbitration institutions with access to best practices in arbitration, help them to align their services with international standards, and enhance their reputation among users. So that's the backdrop. That's where we are now. When you go to a doctor and does a diagnosis, doctor comes out and he says, there's good news and there's bad news. Which do you want first? And most people say, give me the good news first. So we'll start with the good news by way of what I call strengths and opportunities. Remember, we're doing a SWOT analysis. So what are the strengths and the opportunities that exist as a result of this framework that I've just described? Although historically, investment in African economies has focused on the extractive sectors, such as mining, oil, and gas, in recent years, there's been a shift away from exporting natural resources towards manufacturing and industrialization, with African governments increasingly encouraging private sector investments in construction and infrastructure. Given the substantial investment in infrastructure across many African countries, the potential for construction and infrastructure disputes involving African parties is on the increase. This upward trend is confirmed by the results of the SOAS School of Oriental and African Studies Arbitration in Africa Survey Report 2022, which noted that, I quote, according to Deloitte's Africa Construction Trends Report 2021, which tracks infrastructure and capital projects activity across Africa, there has been an increase in the number and value of infrastructure projects in Africa, which suggested figures in the amount of 521 billion United States dollars for 462 projects. The series of disputes involving railways in East Africa, the Kenyan SGR, the Ethiopia-Djibouti Railway, and also port concessions in Djibouti and Kenya are very recent examples of disputes that have arisen as a result of investment in these sectors. Furthermore, with the ratification of the Africa Continental Free Trade Agreement and the adoption of its protocol on investment, with a provision for investors' obligations, there is a possibility that African parties may become claimants in future disputes, especially as African countries are now more proactive and protective of their environment and supportive of domestic labor rights. So perhaps this is an opportunity. However, if the rise in these disputes occurs in these sectors as expected, is the African dispute resolution community ready to participate in more than a passive instructions-giving capacity? Are we ready to take our place before the arbitration panels, arguing for our clients, in addition to sitting on the panels and determining the disputes? In March 2025, the IBA conducted a study on ethnic diversity in international arbitration. From the results, a balanced and diverse arbitral tribunal remains an elusive goal. 68% of respondents noted that arbitral tribunals lack ethnic diversity, and some stated that there's still a long way to go in achieving truly diverse tribunals. Another opportunity? Specifically in Africa, this is supported by the ICC Dispute Resolution Statistics for 2024, which indicates that only 58 out of a total of 1,020 arbitrators appointed in 2024 were from Africa. That's approximately 5%. With the increased push for diversity, coupled with the potential for an increase in international commercial disputes in Africa owing to increased foreign investment, African states have a huge opportunity for greater participation in international commercial arbitration, as increased trade and increased disputes also provide the opportunity for increased participation by African practitioners and African law firms. So we've identified an opportunity. To seize this opportunity, however, we as African arbitration practitioners must take deliberate steps to enhance our expertise, build our visibility, and develop a professional reputation that inspires confidence among clients and appointing authorities. This involves a combination of technical competence, regional knowledge, strategic networking, and consistent engagement with the international arbitration community. I pause for a moment. It's not enough to attend an international conference. We're interested in international trade. We go to the International Bar Association annual conference, or we go to the International Bar Association Arbitration Day, or we go to the ICA Congress. But showing up is not enough. We need to actively participate in those frameworks. So that is what I mean by consistent engagement. To position ourselves to benefit from any potential increase in the number of arbitration disputes, the most critical area for development is strengthening our legal and procedural expertise. Interested practitioners should concentrate on deepening their understanding of public and private international law, international investment law issues, cross-border enforcement mechanisms, and the New York Convention framework, because these are all vital for effective representation in international disputes. In addition, we must deepen our legal expertise in areas of law that frequently arise in African disputes, such as natural resources, energy, construction, public-private partnerships, and telecommunications. Familiarity with trade law regimes, including the African Continental Free Trade Agreement and the WTO, are equally important. And on the procedural side, a strong command of institutional and ad hoc arbitration rules, including those of the ICC, LCIA, ICSID, UNCITRAL, and regional centers such as KIAC, the Kigali International Arbitration Center, AFSA, and CIRICA, the Cairo Regional Arbitration Center, is crucial. Building a track record of excellence is also essential, and this can be achieved by initially acting as co-counsel or local counsel alongside more established international firms. Participating in complex domestic arbitrations and high-profile commercial litigation cases that mirror the structure and complexity of international disputes can further showcase the ability to lead. Where appropriate, practitioners should publish summaries of anonymized awards or notable procedural decisions, especially when these highlight innovative or strategic advocacy. So from this, you can see that my personal experience of Africa navigating international commercial arbitrations has not been as pleasant as I would have liked it to be. Advocacy and case management skills must be continuously refined. enrolling in internationally recognized training programs, such as those offered by the ICC Institute of World Business Law, the Africa Arbitration Academy, DELOS, or the Chartered Institute of Arbitrators, can provide both technical training and professional credentials. Written and oral advocacy must be aligned with global standards, especially in terms of legal drafting, persuasive reasoning, and clarity of expression. Visibility is another essential component. We are not visible in this sector. As African practitioners, we should actively engage with arbitration institutions and networks, such as the ICC Africa Commission, the African Arbitration Association, ICA, and the IBA Arbitration Committee, speaking at international and regional events, such as the ICC Africa Arbitration Conference, Nairobi Arbitration Week, London International Disputes Week, Paris Arbitration Week, can greatly enhance recognition that can also lead to strategic appointments. Contributing articles to leading arbitration publications, including the CLOA Arbitration Blog, Global Arbitration Review, and Afronomics Law, can also establish practitioners as thought leaders in African disputes. It is clear that the international arbitration community is currently focusing on the lack of diversity and its impact on the legitimacy of the international dispute settlement system. African countries have disputes. Africans are not being advocates before tribunals advocating those disputes, and Africans are not sitting on the panels determining those disputes. That is where we are today. But rather than look at it from that perspective, I would rather look at it as an opportunity for change, because the international arbitration community has itself noted the lack of ethnic diversity. Then again, through engagement with institutional and government actors, by providing training or advisory support to ministries, state-owned enterprises, or arbitration centers, practitioners can build trust and position themselves to be counsel of choice in public sector disputes. As I walked along the lobby to get to this venue this afternoon, I looked at the notice board to find out where the Adlon Hall was. And I saw that there's a whole day workshop being conducted for State Counsel by an international law firm. It's probably free, but there's no such thing as a free lunch. They're marketing. They're upskilling our own people. And obviously, in their sector, when those disputes come, who will you think of? The person who trained you? Clyde & Co. They came and gave us this whole day training on this aspect. Now we have a dispute. And I can tell you for free that in every likelihood, they are aware that there is a possibility of a dispute arising, could be 2 years down the line, in a particular sector, and have positioned themselves for that purpose. Why can't our domestic law firms, who have that particular knowledge, do the same for our ministries of justice, our government departments, the legal colleagues in various MDAs? And in the same way, you then find out that having taught and expanded knowledge and information to those who are there 3, 4, 5, 10 years down the line, when there's a dispute that arises in that sector, that the private law firms have reached out to enhance and strengthen government capability, the first likely port of call, all things being equal, is that that MDA, ministry or departmental agency, or that government authority will think of the law firm that trained them to say, we have a dispute. Is this something you can handle on our behalf? Regional knowledge and language proficiency also play a crucial role. Fluency in French, Portuguese, or Arabic significantly enhances opportunities for appointment in Francophone, Lusophone, and North African jurisdictions. And this is somewhere where French African countries have an advantage, because most French Africans also speak English. Maybe not to the fluency that we speak it, but many English-speaking Africans do not speak French. And so you see that French-speaking Africans have an edge where there's an availability for legal representation or appointment. So those of us who are still young enough to have our brains absorb anything, think of taking a course in French. For those of us who are not young enough to take on another language, there's still an opportunity, an appreciation of local legal cultures, state institutions, and regional jurisprudence enables counsel to anticipate and navigate procedural and substantive issues with contextual understanding. So, as they say in my part of the world, a young person may have more clothes than an older person, but an older person has more rags than the younger person. And so that's something in terms of local culture, traditional legal issues that older people can bring to the table. Equally important is the ability to manage complex cases efficiently. I have sat on tribunals represented with African parties represented by African practitioners, and have cringed, not in all cases, but in some, about their ability to manage the case that firstly, to understand the case that they're trying to put forward, and then secondly, to manage those cases. Because leading a dispute requires more than legal acumen. It requires infrastructure. Practitioners should develop or align themselves with teams that are capable of handling massive document review, e-discovery, witness preparation, and expert evidence. The Attorney General I think it was the founding partner, spoke about artificial intelligence and where that would take us. And this is one advantage that may actually enable African practitioners to upskill and be able to take our own place at the table. Then relationships with sector-specific experts, such as quantum analysts, delay specialists, or forensic accountants, adds further depth to a counsel's offering. So these are also relationships that we need to encourage. You have a dispute, what we call in my country, the cocoa, the center of the dispute is money. The claimant wants it, the respondent says you are not entitled to it. Money. The claimant says, I want this much. The respondent says, even if you're entitled, it is this much. The claimant brings damages experts. African countries have not yet utilized damages experts. We go into an arbitration with a mind frame that he who asserts must prove, because that's the litigation mind frame. So you say you need damages, it's left to you to prove it. Whereas in the arbitration space, you have the opportunity to dispute the evidence that is being provided. by bringing your own damages expert to say, no, the way you've calculated your forecast is wrong. You've taken into account things that you ought not to, and therefore this amount needs to come down. So this is something else that perhaps I see as an opportunity. Ultimately, as African Council, we must present ourselves not simply as local lawyers, but as internationally competent practitioners with global outlook and regional insights. This cross-continental mindset, which combines legal excellence with strategic visibility and institutional engagement, is the foundation upon which sustained appointments as lead counsel and internationally acknowledged arbitrators can be built. It must be noted, however, that the lack of African practitioners appearing as lead counsel in international disputes has not attracted as much international attention as the lack of apparent diversity on arbitration panels. Look at the numbers I gave you earlier. Whether it is on disputes involving African states or more generally. The IBA survey earlier referenced also examined the legitimacy of international arbitration in the absence of ethnic diversity. Respondents, particularly in the context of investor-state arbitration, noted that arbitrators in the area were overwhelmingly European or North American, and that this raised concerns about the system's legitimacy. Their position was that diversity promotes effective representation, because when culture is a crucial aspect of the dispute, having someone on the tribunal who understands the culture enhances the perception that the process is legitimate. True life experience. I was on a panel, 2 Europeans and myself. Cross-examination. The respondent states. Witness came up. Thoroughly cross-examined by claimant's counsel. Meanwhile, claimant's witness, elderly man, white hair, very much in his 70s, came up. We expected rigorous cross-examination from the respondent's counsel. We didn't get what we expected. Issues that we thought would be taken up were not taken up. When the tribunal had a break, a tribunal member commented, and their view was that respondent's counsel was close to being legally deficient in representing his client by not having aggressively taken up the claimant's witness on certain aspects of his witness statement, in that he would ask the relevant questions, the claimant's witness would push back, and the counsel would just leave it. And I then had to explain to my co-arbitrators that in Africa, we reverence age. And therefore, it was not so much that the African Council was not diligent in pushing his client's case, but that it was his respect for the white hair of this witness that prevented him from perhaps being as aggressive and as argumentative under cross-examination as the European arbitrators had expected. And it helped to shape the initial negative view that they had of the respondent's lawyer. It wasn't that he was incompetent. It was just that he was reverencing the age of the witness. and that it was something that was not done to tell an elderly person you are lying. Even where the documents showed there was a difference between what you had said in your witness statement and the position you are now taking in response to some questions. Tribunal felt, we should have gone further. You should have told him you're lying. You've said this. In your witness statement, you said that. You should have done that. So at least I was able to ensure that the Respondents' Counsel left the hearing with his reputation intact. He was not an incompetent lawyer. It was his cultural background. Another live example, sitting on a tribunal, and my co-arbitrators are insisting that a hearing goes from Monday to Friday, 10 a.m. to 5 p.m. And we've agreed the procedural timetable. But this is a Muslim country. And so I was able to raise it that we need to have breaks on Fridays if we're going to sit on Friday. Obviously, my European colleagues were like, no, Monday to Friday, we do it, we are gone. But I was able to explain to them that if we're going to sit on Friday, then it has to be maybe 10 to 12, and we resume at 2:30 to 6. Because this is a Muslim country, the likelihood is that the council on one side will all want to go to the mosque. And these are things that we bring to the table. And where there's no diversity on the tribunal, the side that does not have its case fully represented, just by taking ethnic and cultural issues into account, may feel that the system is not legitimate. In summary, the findings of the IBA study demonstrates a strong consensus among arbitration stakeholders of the positive impact of ethnic diversity on arbitral tribunals. 89% of the surveyed respondents believe that ethnic diversity improves perceived legitimacy, and 80% feels it enhanced perceived fairness. As key next steps, the survey advised that they should increase the visibility of arbitrators from diverse ethnic backgrounds while promoting awareness and education on the topic. So in my view, this presents a unique opportunity for arbitrators of African origin to engage with the international arbitration community, fostering greater involvement in the global dispute resolution arena. A first step in achieving the objective is the increase in the appointment of African arbitrators in international disputes that have a connection with Africa. And I hope the Attorney General is still with us and is listening. If we do not have the confidence to appoint African nationals in disputes that affect us, how can we expect other countries to have confidence in this respect and to have confidence in the expertise of African arbitrators? But I have good news. The Republic of Ghana is to be commended in this respect, as it has recently appointed an African as arbitrator in a state dispute, and that was Anglo Gold Ashanti Ghana Limited versus the Republic of Ghana. And it's an ICSID case, so you can check it online and see who the parties were. However, reputation, recommendation, and prior performance are crucial to securing appointments. We must remember that arbitration is confidential, and we are unlikely to know of the comments passed on our performance when recommendations for an appointment are sought. So let's not do the old boys club. You're appointing an African arbitrator because he's your friend or the friend of a friend or a colleague. The appointment of an inexperienced arbitrator based on personal relationships reflects poorly on all arbitrators of African origin. Clients, co-arbitrators, tribunal secretaries, and co-counsel. These are the people who may be approached when a party is seeking to appoint an arbitrator, because they can provide confidential, vital information or endorsement. A strong reputation for responsiveness, procedural fairness, and ethical conduct can distinguish an African counsel from international peers and open doors to appointments. Practitioners should also seek inclusion on rosters and panels maintained by institutions such as ICSID, the World Bank, or African Development Finance institutions. For ICSID, every country appoints 4 members to the ICSID panel of arbitrators. And if you look at the ICSID panel, I don't know about Ghana, but many African countries have appointed arbitrators, and your appointment, I think, is 6 years. Many African countries have appointed arbitrators in 2011. They've forgotten about it. Those people are still there. They have not refreshed their list. And ICSID is not going to ask you to refresh your list. It is for the country to know that it has a list, that those appointments are expiring, and there's an opportunity to replace with fresh faces and new people who have the expertise. So if a country has appointed a panel to ICSID, and that arbitrator has not received one appointment in the 6 years that he has been on ICSID, then perhaps the country needs to look at putting someone else. In similar fashion, African state parties have often chosen to arbitrate their disputes in jurisdictions outside Africa. I think it was the Attorney General who referred to exporting our disputes. So we export them to jurisdictions outside Africa, and we appoint non-African arbitrators, and we retain non-African counsel as lead counsel. It's not in dispute that the international disputes favored seats are London, Paris, Singapore, Hong Kong, and Geneva. And within the confines of this room, I will tell you that I have heard from European arbitrators with a laugh. Oh, you know, we went to discuss this dispute and we were talking about the seats. And it was like, oh no, we're going to London, the shops there are better. I don't know the shopping in Geneva. No, we're not going to Singapore, I don't know the shopping, it's London, the shopping. And when we go for any arbitration, we have to make sure that we close before the shops close. I mean, these are comments that are maybe made casually, but they're passed on and on and on. Or for whatever reasons, Paris, London, Singapore, Hong Kong, and Geneva. To provide the opportunity to change the narrative as far as arbitral institutions are concerned, we have the Kigali International Arbitration Center, the Tanzanian Arbitration Center, pushing themselves, positioning themselves to be alternative seats for arbitration. However, in spite of these institutions' recent partnerships with the Permanent Court of Arbitration, that is AFSA, and LASIAC, still the preferred seats still remain ICC, PCA, London, LCIA. Nonetheless, efforts are still being made to ensure a change in perception. Countries like South Africa recently held a Johannesburg Arbitration Week. And during that week, the South African Arbitration Alliance was established. 10 Southern African Development Community states formed an alliance with AFSA. So they're already positioning themselves as a seat for international arbitration. Let's watch the space and see what happens. But the idea is that this strategic development is expected to reshape arbitration in SADC member states and promote cooperation between them. It is the expectation and the hope that with the increase in arbitral institutions across Africa, there would be an increased promotion of arbitration on the continent, particularly with an increased pool of highly qualified African lawyers and arbitration practitioners, and that more cases will be dealt with on the continent. Further still, on the subject of promoting arbitration on the continent and not exporting our disputes, the point must also be made that African parties must recognize the difference between the seat of arbitration and the venue of arbitration. If our foreign partners insist on the arbitration being seated outside the continent, the African parties can at least insist on the arbitration being heard on the continent. By that, the African parties can retain the economic benefits that accrue to a country from arbitration proceedings by insisting that they retain the venue. These benefits are not only acknowledged, but they are actively sought after by other locations. As far back as 2017, at the 35th Annual Donald O'May Maritime Law Lecture in London, Lord Gross stated, and I quote, "The UK Legal Services Centre contributes £25.7 billion to the UK economy, or 1.6% of gross value added. It generates £3.3 billion in annual export revenue. Such figures matter in themselves. They also bolster the attractions of the city as a financial center." So that's money that we're allowing to leave the African continent when we refuse to insist that, okay, you want your seat in London, no problem. You want English law to govern the contract, no problem. But if there's any arbitration, the venue of those proceedings must be Accra, Ghana, or anywhere else. Let the arbitrators fly into the country. Spend their money staying in your hotels. Use your taxis. Go to your markets and do their shopping. Let the witnesses also fly in and do likewise. These are some of the economic benefits that accrue. Use your arbitration venues. These are the economic benefits that accrue from arbitration. However, any country wishing to position itself as an acceptable location for arbitration proceedings must ensure that there are functional facilities for the provision of such arbitration services. This includes the ability for transcription services, hearing rooms, document handling, management services. Such countries must ensure easy accessibility to the country. How easy is it to get a visa? Free from unreasonable constraints on entry. Ability to work, to come in and to go out for the parties, the witnesses, and the counsel. And adequate safety and protection of the participants, their documentation, and their information. That's what it takes to be a good venue. What are your airport links like? How easy is it to get to Accra from Tokyo, from Toronto, from London, from the US? As arbitration increases on the continent and trust builds in African practitioners, both as counsel and as arbitrators, African states must now sustain the same by maintaining a conducive environment for that trust to flourish. One major way to achieve this will be to ensure that national courts and judiciaries have a pro-arbitration mindset when dealing with cases. I sit on the court of SIAC, Singapore International Arbitration Center, and one of the reasons why SIAC has become so popular and Singapore as a seat for international arbitration is because when awards come out and somebody challenges the award and the award is overturned, the Ministry of Justice wants to know why was the award overturned, and if it is something in their legislation that has resulted in the award being overturned, they'll change their law. They will do anything that it takes by amending their legislation to ensure that international arbitration is well supported by the courts of Singapore. Not like African countries where we change it. In fact, to change the law, that itself is a lifetime experience. So we must have African states ensuring that national courts and judiciaries have a pro-arbitration mindset. And indeed, we're beginning to see a shift in this direction in several courts, in several countries. Tanzania has recently given a judgment in it which it held that applications for the set-aside of foreign-seated arbitrations, the only grounds which can be considered are the provisions of Article 5 of the New York Convention, and that this is domesticated in Section 83 of the Tanzanian Arbitration Act. So I've reviewed the strengths, the opportunities that exist as we navigate international commercial arbitration. And I've given you the good news. The good news is that the international arbitration community are aware of the lack of diversity and want to change it to ensure that the system remains legitimate. So it's an opportunity for us to take everything we need to do to fill that gap. But like I said, I've given you the good news. Let me give you the bad news now. Weaknesses and threats. Despite all the strengths and opportunities that I've outlined above, and despite the clear growth of arbitration and international commercial disputes across the African continent, most international commercial cases and disputes involving African states and parties are still settled outside the continent. And as I said before, this is due to a general preference for foreign law or a foreign seat by non-African parties and foreign investors, and sometimes even African parties. Indeed, most commercial parties involved in international commercial disputes in Africa choose a foreign seat, a foreign country, as the seat of arbitration. Looking at the ICC Dispute Resolution Statistics 2024, 8% of the total parties, 194 parties from 31 countries out of 2,392 parties, 8% were from Africa. However, although arbitrations filed in 2024 were seated in 107 cities across 62 countries or independent territories, only 12.9% of African countries were selected as the arbitral seats. That is 8 countries out of 62. In fact, the recent White and Case and Queen Mary survey 2025 revealed that 60% of Africans who participated in the poll chose London as the preferred seat of arbitration. The reasons for this preference for foreign-seated arbitrations in disputes involving African states, apart from the shopping, even by African parties, which were identified in the SOAS report, provide a basis for reflection towards turning an identified weakness into an opportunity for change. Some of the reasons include sophisticated arbitration laws and structure. We are working on that. We've seen that it's now a strength, it's an opportunity, as well as the excellent reputation of the resident arbitration institutions in those foreign seats. To stop the export of African disputes, which many African practitioners complain of, change needs to start at home. The White and Case Survey, 2021 survey, found that greater support for arbitration by local courts and the judiciary, increased neutrality and impartiality in the local legal system, and a better track record in enforcing agreements to arbitrate and arbitral awards were the key adaptations that would make other arbitral seats more attractive. Clearly, this suggests that changes to local legal systems to ensure that a seat offers a supportive judiciary and an impartial court system have the potential to make certain African countries more appealing as arbitration seats. Furthermore, African countries often have weak bargaining power against foreign investors, as I have said. Although African governments are no longer passive, they remain reactive to the overtures of foreign investors and cannot fully set the terms of engagement during negotiations involving significant capital and are often obliged to make concessions to obtain the investment. So if the people negotiating the contracts in the first place do not have the requisite knowledge and experience, things that should not be given away, such as if you don't understand the difference between an arbitration seat and an arbitration venue, and you give everything away on the basis of a seat without making that distinguishment, these are issues that we need to refer to. We should not see ourselves as agreeing to everything that the foreign investor is asking for just because we need that investment. With the way things are going in the world, with the emphasis on foreign minerals, Africa is now the bride for many countries. And we shouldn't take the back seat and assume they need us more than we need them. Or perhaps let's say we now need each other equally because we need their money, but they also need what we have, our lithium, our copper. It's not just the oil and the gas anymore, our gold. So, to further illustrate, the 2022 SOAS survey indicates that for public law projects, while African states may impose their governing law, non-African parties often insist on arbitration outside Africa. The foreign party does not want to take the risk of finding itself before a local judge. Why? The choice of a seat is a vital decision for the parties. It will have a significant impact on how the arbitration is conducted, its efficiency, and how easily any award can be enforced. A country whose judiciary is seen as weak, corrupt, or inefficient will be regarded unfavorably as a potential arbitration seat because these problems weaken the essential protections needed for a secure and effective arbitration. You can have the best arbitration center in the world. It can be equipped with all the digits that you require, digital, video phones, video this, AI, everything, translators. if the judiciary that is supposed to support the process is either seen as being ineffective, it detracts from the potential ability to be determined as a seat. Inefficiency or delays can seriously hinder the supportive and supervisory role that courts at the seat are expected to provide. A weak judiciary may stem from a lack of technical competence or specialized knowledge or that is needed to handle complex arbitration issues. Arbitration frequently involves subtle questions of international, commercial, or investment law, requiring judges who are familiar with the relevant legal principles and attentive to the distinctive features of arbitral autonomy. Nigeria had another case after P&ID. Everybody knows about P&ID. But there was another case after P&ID, Fucheng versus Nigeria. It was a Chinese company. It had an agreement not with the federal government, but with the state government. And when a dispute arose, it filed an investment claim. And a lot of discussion went on within Nigeria as to what's Nigeria's business in this? Why have you sued the Federal Republic of Nigeria? You don't have a contract with the Federal Republic of Nigeria. You have a dispute arising with the state government, the subnational entity. And it was clear to many people who took this view that they did not understand that one of the principles of international investment law is fair and equitable treatment. And one of the claims that this Chinese company had made is that when they got into this dispute, state government used, we have one police force, federal. State government had used the police to harass the managers of the company, had locked them up, the state security service had been involved, immigration had been involved, checking whether they were legal in the country or not. And that this breached international principles of fair and equitable treatment. Now, if a judge doesn't understand that there are principles that exist that are specific to arbitration, then in such cases you may have decisions coming out of domestic courts that do not align with arbitration jurisprudence. So, as I said, arbitration frequently involves subtle questions of international, commercial, or investment law, requiring judges who are familiar with the relevant legal principles and attentive to the distinctive features of arbitral autonomy. Real life example. I sit on a panel, domestic arbitration. Both parties asked for document production, which basically means we want you to provide certain documents. Tribunal of three, we gave our decision. Some documents we said should be produced, some we said should not be produced. The party whose requests were refused went to our local court, told the court, referred to some portions of our Arbitration Act. The judge set aside our procedural order, saying it was an award. Sooner or later, that decision is going to get into the international arbitration space. It's not going to look good for our judiciary, but it is what it is. So we need our judges to also be informed about arbitration processes and procedures and what can be done and what cannot be done. Another problem with the judiciary of African states is the lack of speedy resolution of cases. They go so slowly. And whilst this is a significant challenge for many African judiciaries, given the volume of cases that need to be dealt with in any given period, the problem has been recognized and some countries are taking steps to rectify the issue. So for instance, using Mauritius, which seeks to be a center for arbitration of African disputes, on the 24th of January 2025, it launched a 5-year program which outlines key judicial reforms, establishing a new appeal court for matters that come from its Supreme Court and arbitral tribunals, all in an effort to speed up its review of arbitration-related matters. So a dedicated court to deal with arbitration and investment cases in many African states, or even a regional court dedicated to supporting arbitral proceedings on the continent, are things that have been proposed as a way of strengthening the judicial system in Africa and making it easier for African disputes to be resolved on the continent. Finally, in jurisdictions where judicial corruption is seen as widespread, parties may worry that court decisions related to arbitration, such as challenging arbitrators, annulment proceedings, or enforcing awards, may not be made impartially or based on legal merit. What is seen as a weak point in Africa's relationship with international arbitration should actually be taken as an opportunity to redress these issues, which forms one of the reasons why African disputes are being exported abroad. Lack of governmental expertise. Many times, African government officials, and in some cases, even legal representatives, appointed to negotiate investment contracts and BITs, fail to conduct thorough research and prepare for the negotiation process. African countries often attend international negotiation sessions with few representatives due to a lack of human capital, qualified experts, and also financial resources. Of various skills and talents within the negotiating team and uncertainty about where to turn to if technical information is needed can hinder the implementation of a favorable deal. The English court noted this obvious gap in the P&ID case when on appeal, Justice Knowles said, I quote, "It was a complete imbalance in the contributions of the parties that enabled the GSPA to be in the form it was. Many reading this judgment will recognize that although in the present case, bribery and corruption were behind that imbalance, it happens in other cases without bribery and corruption, but simply where experience, expertise, or resources are grossly unequal. This underlines the importance of professional standards and ethics in the work of contract drafting, including in the approach to other parties to their proposed contract. It is why some contribution of pro bono work by leading law firms to support some states challenged for resources, that is not to say one way or the other that Nigeria is one of them, is so valuable in the interests of their often vulnerable people. So I will presume that White and Case are here in the next room giving pro bono legal support services to your Ministry of Justice. This imbalance and the lack of expertise also rears its head when disputes arise and consequently results in inefficiencies during the arbitral proceedings. I go back again to another comment from the P&ID case where the court said, I quote, "But the case has shown examples where legal representatives did not do their work to the standard needed, where experts failed to do their work, and where politicians and civil servants failed to ensure that Nigeria as a state participated properly in the arbitration. The result was that the tribunal did not have the assistance that it was entitled to expect, and which makes the arbitration process work. And Nigeria did not, in the event, properly consider, select, and attempt admittedly difficult legal and factual arguments that the circumstances likely required. Even without the dishonest behavior of P&ID, Nigeria was compromised. So while legal reforms have improved the landscape in many jurisdictions, continued investment in legal capacity is still necessary to sustain and enhance investor confidence. And this is an area where the private bar can be of assistance in partnering with government legal counsel in relevant training programs. My conclusion: according to the African Development Bank Group, there is enormous potential for Africa to raise capital through better resource utilization. The ADB estimates that up to $1.43 trillion could be mobilized through increased efficiency in tax and non-tax revenue collection. Africa's natural capital is particularly underleveraged. The continent holds 30% of the world's mineral reserves and stands to capture over 10% of an estimated $16 billion in revenues from green minerals by 2030. Further still, Africa's youthful population, with a median age of 19, also represents a democratic advantage. With improved labor participation, the continent could add $47 million to the GDP, and the full implementation of the African Continental Free Trade Area can also lift exports within African countries by $560 billion and increase income by $450 billion by 2035. Therefore, as the market and the economy grows, it is important for the dispute resolution mechanism to grow alongside and provide efficient and effective structures and institutions be put in place to manage the influx of disputes that naturally will follow. African states, while emphasizing the promotion of inward investment, face an escalating risk of investment disputes. And it is not in dispute that investment disputes pose a significant financial burden on the treasuries of African countries. The fees levied by international law firms engaged by African states for dispute defense significantly contribute to the financial strain on state treasuries. Even when domestic counsel, whether external or in-house, are engaged as co-counsel, they frequently lack opportunities for skills enhancement through collaborative representation with these international law firms. Anecdotal evidence indicates that in numerous cases, the function of local counsel is often diminished to merely acting as a post office to offshore international counsel, or to confirm that the proposed interpretation of domestic law by the International Council is accurate. This lack of skills transfer has prompted some African governments to focus on developing internal capabilities within their ministries of justice. Again, in this respect, the republics of Ghana and Kenya provide shining examples. In Beijing Everyway Traffic and Lighting Company versus Ghana, Ghana employed a government legal team to effectively defend the claim. In Walam Energy versus the Republic of Kenya, Kenya represented by a team led by its Attorney General and various state counsel, along with international and Kenyan law firms, also successfully defended itself against a claim filed under the Canada-Kenya BIT. However, Tanzania, which appears to have also committed to utilizing its Ministry of Justice for legal representation has not been so fortunate, as it was deemed liable for expropriation in a claim filed against it under the Sweden-Tanzania BIT brought by Spanish investors. A potential compromise would be the stipulation that states intending to engage international counsel must appoint domestic co-counsel and require one or two state counsel from the Ministry of Justice to intern with the selected international law firm for the duration of the engagement, thereby enabling African states to acquire the necessary expertise in managing investor-state disputes over time. Then again, employing competitive tendering processes to secure international counsel for investor-state disputes will promote transparency and reasonableness in the costs associated with the internship within the total fee proposal, thereby diminishing the potential for inflated fee submissions. An analysis of fee estimates can also aid states in assessing whether or not to settle the matter. Perhaps settlement is more profitable and a more feasible option than paying the huge fees that the international law firm is asking for. So finally, African states must adopt a systematic and a consistent executed strategy for training both state counsel and external counsel in the complexities of international investment law and arbitration. As I have suggested elsewhere, and because it's me, I'm now quoting myself, with the increase in investment disputes in Africa, states which are less conversant with the intricacies of the ISDS system can leverage on the legal skills available in other African countries that have attained a level of expertise through acting for respondents in investor-state disputes. This collaboration between the legal communities in different states is vital for African states wishing to increase their profile in the investment arbitration space on the African continent. Perhaps if Tanzania had done that and got Kenya to assist, the outcome of the dispute may have been different. Thank you very much for your attention.
Wow. Well done. Wow. To deliver that in close to an hour, taking only 2 sips of water without batting an eyelid, I mean, I wouldn't want to appear before her. Under any circumstance. Round of applause one more time for our keynote, Funke. Now, we'd like to breeze straight into the panel discussion. So I'd like to bring up the panel members, and then I'll call our moderator. But she gave us 9 big ideas, just for those who are sort of journalistically trying to track this. So she spoke on legal and regulatory reform, and then she dealt with building confidence in African arbitration institutions, and then she plowed through the issue of judicial support and challenges, and then the almighty diversity question and representation in arbitration, and then capacity building and skills transfer, very important. So not all trainings, no free lunch. Negotiation power and government expertise. Age, you'll be happy to hear this. Economic and strategic implications. Seat and venue are not the same. That was quite an eye-opener. Regional cooperation and knowledge sharing. And of course, she gave some takeaways, structuring those in the SWOTs, the strengths, weaknesses, opportunities, and threats. Thank you so much, Madam, for taking us through those lectures. I'd like to bring up our panel members. Ace Ankomah, Senior Partner at the Bentsi Enchill Ankomah Law Firm, almost 30 years in the field. And Ace has headed the disputes practice group of the firm. and responsible for a lot of contentious matters. And of course, he's represented several local and international clients, including the IFC, Bank of Ghana, etc. Key point for us in the media, many years ago, Ace headlined a case in Ghana against Argentina that led to the arrest of a war vessel without a gun. He arrested a vessel like Moses before the Red Sea. And that led to the settlement of over $2.4 billion. And Ace has represented other clients in arbitration, Valco, Kaiser, Western Telesystems. He's done the whole shebang. Couple of points worthy of note. Ace, 10 years ago, the University of Ghana instituted the Ace Ankomah Prize in Constitutional Law in his honor. And of course, he was trained at the University of Ghana and also Queen's University in Canada. He has lots of memberships, including the GBA, the ICSID panel arbitrators, and the board of Lex Mundi, and a fellow of the Aspen Global Leadership Network. Ladies and gentlemen, Ace Ankomah, please put your hands together for Ace. Yes, please come and sit down. Our next panelist is Emmanuel Amofa, founder and managing partner of Amofa and Partners. Areas of expertise include corporate law, investment law and negotiation, arbitration and mediation, civil litigation, thank you Ace, land law, international commercial law, international business transactions, etc., etc. And his expertise in domestic and international arbitration practice, and has acted as counsel and arbitrator, served as sole arbitrator, co-arbitrator, and chairman in several domestic arbitrators under the rules of procedure of the Ghana Arbitration Center, etc., etc. And he's also been the administrator of the Ghana Arbitration Center since its incorporation in 1996. Now, keynote, he was lead counsel in major international arbitrations involving state parties and multinational companies under the auspices of the London Court of International Chamber of Commerce. He also teaches, as a lecturer in alternative dispute resolution mechanisms at the Ghana School of Law, and he has a lot of his students here. Let's put our hands together for Emmanuel Amofa. Thank you, sir. And last but not least, in terms of our panel members, Kizito Beyuo, been managing partner for Beyuo & Co. since establishment in 2008, worked at Tete & Co. from 93, where he was a pupil. He became senior associate in the year he founded his own law firm. With over 3 decades of legal expertise, he's built a robust practice that spans corporate and commercial law, with special focus on dispute resolution. He was appointed a notary public for the Republic of Ghana 2004. He has cultivated a distinguished litigation career experience, represented several clients in high court, in fact all the courts, and his passion for imparting knowledge and mentoring upcoming lawyers has led him to take up positions as lecturer in civil litigation at the University of Ghana School of Law. And of course, he's a seasoned arbitrator as well, served as a co-arbitrator in over 10 high-stakes commercial arbitrations covering industries including franchising, manufacturing, energy, technology, real estate, and stevedoring. He continues to serve as co-arbitrator in several high-value disputes. And of course, memberships of many things under the London Court of International Arbitration, the FCIArb, ICC, and previously sat on a couple of national boards as well. So Kizito Beyuo, ladies and gentlemen, round of applause. Now, Kizito, thank you. We are very happy to now bring up our moderator, who's a partner at Bentsi Enchill and Ankomah, regularly advising and representing clients in a range of high-value litigation and arbitration disputes, and is highly regarded by her peers and clients for experience in cross-border disputes. She also sits as an arbitrator in both international and domestic arbitrations in institutional and ad hoc proceedings. She has been appointed a sole arbitrator and co-arbitrator by the FCIArb, ICC, and the Ghana Arbitration Center, etc., etc. Now, some of her blue-chip clients: Talo, Epiroc, Stena Drilling, Champion X, Stanbic Bank, Anglo Gold Ashanti. You know where I'm going. Lots of money. No, and it's such a broad range, including FBN Bank and even the Church of Jesus Christ of the Latter-day Saints. And interestingly, she's also co-chaired the African Arbitration Group of International Bar Association Committee. She also teaches alternative dispute resolution at Ghana School of Law and is called to the bar both in England and Wales and in Ghana. Ladies and gentlemen, your moderator for the panel, Nania Owusu-Ankomah. And Nania, I think Funke will join the panel. All right, go ahead, please.
Thank you.
Yeah. Hello, everyone. Good evening. Thank you so much. And Funke, thank you so much for such an insightful lecture, and especially for encouraging all of us on the panel to dissect your views. And we can't dissect your views without you being here, so we've invited you to join us. Ladies and gentlemen, thank you very much. I have to say that it's such an honor for me to be here. I'm personally elated because there aren't very many occasions where you get to put questions to your senior colleagues. And trust me, I'm going to make the most of it. But don't worry, I will make sure that I respect the gray hairs.
Sorry.
Now, we'll dive right into it. Mrs. Adekoya, you stressed on the importance, if a country wants to be an attractive seat, why it's important to have a good legal framework. And during the lecture, you talked about some of the countries that have modernized their arbitration laws. I wanted to find out from you whether you think that these modernization of the laws have had a practical impact on foreign investors deciding to choose those countries as seats.
I think it's too soon to tell. You change your laws today, you're negotiating your disputes today, the disputes will not come up for maybe 5-6 years, if they do come. But I think that for those who are looking at negotiating the contracts today, the changes in the legislation will be beneficial for the investment coming in. Whether those countries will then become the seats, the verdict is still out. It's too soon to tell.
And Kizito, from your perspective, are there any specific legislative changes that can make a tangible difference to the attractiveness of a country as a seat?
Of course, yes. What you just have to look at what is happening in the global space. The ancestral model law is modified with time. You would notice that in 2020, Sierra Leone acceded to the New York Convention. That's how come it amended the law to go along the New York Convention. Nigeria, which had fallen behind, we tease them that we are their forerunners. Their act now incorporates the ancestral model law. You have the New York Convention. So yes, as Funke rightly said, it is too soon to tell. But when investors are negotiating arbitration agreements, they want to be assured that the terrain is something that they can comfortably play in. So if your law is fashioned along best practices in international arbitration, yes, it would have an impact.
And Ace, let's bring this home to Ghana, and I'm glad that the AG is here. Do you think there are any legislative reforms that you would recommend for Ghana if we are looking at making Ghana an attractive seat?
Absolutely. We passed the Act 798 in 2010. And so we are 15 years down the line, and we've engaged it in several ways. And I think it's time to take a look at some of the provisions and how they've been applied. The first and obvious one is the Section 1. And Mr. Attorney General, if we wanted to do a carve-out non-arbitrability, there's a way to do it. But when our act says, it wasn't you who passed it, but when our act says that this act does not apply to these, and you say things like matters of national interest. If we have a dispute with Cote d'Ivoire over oil, there's national interest, but we went to arbitration. And so there's a need to look at some of those sections and tweak them. But I must also say that Ghana has legislatively been very supportive of arbitration. When the New York Convention was passed, even before we completed international accession, we passed the 1961 Act and completely codified the New York Convention in Ghana. And it was about 7 years later that we sent our accession documents to New York. And so we have been very arbitration friendly, but there are quite a number of sections that we've come across. We need to, for example, clarify the whole Is a Section 8 link between the courts and how the courts support the system? We need to clarify, for example, whether we consider interim awards as enforceable awards in Ghana. And there's a whole international jurisprudence going on about that as well. And certainly we need to provide that the horror you spoke about, where a procedural order is interpreted as an award and therefore set aside by a court, does not happen in our jurisdiction. So there are dime a dozen, but there are several things in the act. The act was very forward-looking, but it's already out of date because of the new ancestral model. We need to look at that and see what changes we can make.
Okay, I mean, there's been some debate about whether judicially, when you look at the courts, whether the judges can, perhaps by way of judicial interpretation, make some of these changes. And of course, that's not possible at all. So it's definitely something that we want to look at. But moving on from Ghana as a country, I want us to think about arbitral institutions. I mean, Emmanuel, you have been at the helm of affairs at the Ghana Arbitration Center for several years. And I just wanted to find out from your perspective, what can arbitral institutions do to stem this tide of exporting disputes? We can see that there are lots of barriers to building trust in arbitral institutions on the continent. What can we do?
I think that the first thing that one has to look at will be negotiating the arbitration agreement in the first instance. Because if you negotiate that arbitration agreement and choose other institutions outside Africa, then you have driven yourself out of the arbitration space. So the beginning is for parties negotiating the arbitration agreement to choose institutions in Africa. In this case, Ghana Arbitration Center, I will speak for myself. Yeah. The other thing is about the arbitration practice, African arbitration practitioners. Some will literally, deliberately choose arbitration institutions outside Africa. So, shopping, let us go to LCIA, ICC, and all that. So there has to be a deliberate effort on the part of African arbitration practitioners to choose institutions in Africa. There are a lot of institutions in Africa, and there's no reason why we should be looking outside. But when you talk about choosing arbitration institutions in Africa, then you should be talking about the institution itself. The institutions must position themselves in a way that they can administer arbitrations internationally and domestically.
So when we talk about positioning, the institution positioning itself, I want to come to you, Kizito, because I know that you are very much involved with the Ghana Arbitration Center. How can these African institutions market themselves, so that there's trust and they're able to attract some of the work?
So I take a cue from the word used, trust. Arbitration is essentially about trust. You can have the best facility, but if the users of your facility don't trust that you can deliver, then they won't come to you. Okay. So arbitration institutions in Africa must put themselves in a position that they can deliver effective arbitration proceedings. Fortunately, we have AI. We can leapfrog. We don't have to crawl. We don't have to dandle. We can leapfrog. We can partner with established institutions outside, build capacity over the years. By the time the contracts that are being negotiated now get into a dispute stage, we should be in position to manage some of these high-value arbitration proceedings. It's the best way to market, is to show what you are capable of doing, and that's when people will come to you.
And Mrs. Adekoya, just coming back to you, you talked about the role of the judiciary, and you talked about sometimes there's a perception of judicial inefficiencies, corruption. And I wanted to find out what, in your view, are effective strategies that we can adopt to combat these perceptions and perhaps also strengthen the judiciary to be able to play their role well.
I think the first thing that needs to happen is a conversation between the bar and the bench, in which the bar needs to make the bench realize that the decisions that they take are not restricted to their courtrooms. You're going to have, they may want to enforce it abroad. I've been in a position where a UK law firm got in touch and wanted clarification of a Nigerian judgment. The judge had said, order has prayed. The applicant had sought for judgment in a particular amount with interest at a particular rate. And the judge had said, order has prayed, judgment in this amount, interest at 10% until payment. The question the American court wanted, was it simple interest? Was it compound interest? So I had to start looking into what our legislation says about where courts order interest. But if the judges realize that the decisions that they take may be read outside of the country, they may be more careful and more thoughtful about the decisions that they render. And then with that, the relationship between the bar and the bench, where arbitration is involved, it is possible for the Ghana Arbitration Center to run courses for judges. I know in Nigeria, Chartered Institute of Arbitrators, we constantly hold courses that we invite judges. This is for you, just to explain to them what arbitration is about, the relationship between arbitration proceedings and the courts.
And Kizito, just picking on, sorry, Emmanuel, I think, let me ask you this question. Just picking up from Mrs. Adekoya's lecture, she mentioned the Mauritius experience where they had established, specialized courts to deal with arbitration. And I wanted to find out, do you think that that is a good model for us in Ghana? How do you think that can help?
Well, specialized courts for arbitration, that's maybe a preference, but I think that if you have courses which specialize in arbitration and you do not touch the rules, if these courts are established but have to apply the same CI 47 without any amendment to suit the arbitration, because arbitration thrives on speed. If you don't modify your rules, there ought to be a deliberate effort to modify the rules if you are establishing specialized courts. In fact, we have the commercial courts. It's commercial court, but part of it is that the commercial court will deal with arbitration disputes. I mean, trying to refer parties to arbitration. Yeah, that is there. But if you have a specialized court applying CI 47 without any modification, then you are not going to achieve what you want to do. And I think that we may be looking at the Nigerian experience of Review Arbitration Board, something to that effect. And then also, very important, you have a specialized court, you don't try and reorient lawyers' mentality towards arbitration, and they apply their technicalities, then you are not going anywhere. So the rules ought to be modified to suit any specialized thing that you may want to introduce.
Yes, and certainly I think beyond that, if you have specialized courts that deal with arbitration-related disputes, you must have judges that understand how to deal with such disputes. And I think, if you're an arbitration lawyer in Ghana, at least you know about 2 judges in the commercial court who frequently deal with arbitration matters, and therefore, you are happy or you prefer that your matters go before them. But when you go outside that can be a bit of a challenge. So, building the judiciary itself is also important. Kizito, do you think that there are any models that Ghana could follow? What are some of the reforms that have taken place in other countries, and what do you think we can learn from that?
Well, as Ace pointed out, we've had our act for the past 15 years. The UNCITRAL model was fashioned along the UNCITRAL rules. the Austria model has introduced some changes. So these are, and that's why some countries which were using the English Arbitration Act as the basis have modified. If you take Nigeria, if you take Sierra Leone. So yes, there are changes we can make to align ourselves with international best practice. But we should be intentional about the changes we make. I'm happy that the Attorney General is here. Singapore is the second preferred arbitration destination. Funke mentioned that among the respondents, 60% of African respondents chose London first, Singapore second, I think Dubai was last. So if 60% of arbitration practitioners in Africa will choose Singapore, you ask the question why. It is because the government in Singapore has been intentional in creating the legislative framework. The amount mentioned by Funke as the contribution of legal service or arbitration to UK's GDP is 1%. The legal services in Singapore is contributing 1% to Singapore's GDP. Attorney General, if we have the legal service arbitration contributing 1% or even 0.5% to our GDP, you can imagine what it will bring us. So yes, we should make our space consistent with best practices, make sure our legal sector is such that, and the example Funke gave, once there's a decision which generally people find is out of sync with arbitration practice, what government does in Singapore is to amend its arbitration rules so that people will become comfortable bringing arbitration disputes to the country. So we should be intentional about what we do.
Thank you. And I want us to talk about the big elephant in the room that Mrs. Adekoya mentioned, diversity. And Ace, I want to come to you. You know that there have been several institutional initiatives and policies to deal with diversity. How effective have these initiatives been, in your view?
It's picking up, but from my earliest engagement in arbitration, it was, and pardon my French, it was a white boys club. It's a bunch of white male men who sat on arbitration. But so the institutions themselves would have to look at who they empanel. But often it is, if it's appointed by the parties, then one would expect that the parties would appoint people to reflect diversity. And let me be honest with you. I was involved in one arbitration where we were sure that the arbitrator appointed by the developing country was the one who really negotiated the very low damages we got. And the whispers was that he said, look, this is a developing country, they're struggling, yes, they breached the law, but if you hit them with this amount of money, what is going to happen? So we either get a good figure or I write a dissenting opinion. That is the information we get subsequently. And since every panel wants a unanimous opinion, because if it's a majority opinion, nobody's going to cite it. Because they want that negotiated. So it is in our interest as a developing country to ensure that we appoint panel members who understand where we're coming from and the diversity reflects. Let me give another example. You must have read the blistering dissenting opinion by Thomas Mensah in Ghana, Cote d'Ivoire, right? You could tell where his heart was. And in one arbitration appeared before him, appointed by a state government, you could see that, yes, he knew that the country had, that country had breached the law, but he was also using his knowledge of the law to ensure that our diversity reflects. So the diversity is in terms of nationality, but it's also in terms of the gender balance on the panels. Because when the diversity started coming up, then it became more, now this time, male, so it was still male dominated. And so we need to look at diversity not only from the perspective of nationality, but also with gender. But just to hack on another thing, we need to resolve the issue between voluntary arbitration, which was what the ADR Act provides, and compulsory arbitration, which several statutes in Ghana provide for. Now, if you provide in an act that disputes under this act will be resolved under the Alternative Disputes Resolution Act. But when you go to the ADR Act, it says that it is a voluntary submission of disputes. So if the statute is forcing me, is it voluntary? We need to, and it's all we need is one section. There was a section in the 1961 Act, which India still has. And you can see that one of our judges was led by that, assuming that that provision still existed, which says if arbitration is quote unquote imposed by statute, by agreeing to operate in that area that is covered by the statute, you are deemed to have agreed that your dispute be submitted to arbitration. When we did the 2010 Act, we, I think, forgot about that link, and it's something that we have to think about bringing back. But it boils down to the fact that if the government side and the practitioners sit down, there are a lot of things that the practitioners have seen with the law, and we could suggest that to the government for amendment in the way that the others have spoken.
Thank you. I mean, although you are my boss, I'm going to have to be cutting you very soon when you are answering questions. So please bear with me and save me from maybe the subsequent problems that I'm going to have when I cut off my boss when he talks for too long.
Yeah.
Now, I just want to come back to the diversity issue. You mentioned gender diversity, you mentioned ethnic diversity, but I mean, talking about myself, I mean, someone in my 40s, there's also age diversity that must be, factored into the mix. In arbitration, if you are in your 50s, you are considered young, and that is something that must change. I wanted to ask you, Emmanuel, how do you think the international arbitration community can be encouraged to embrace diversity, especially on tribunals? What does diversity on tribunals bring?
Well, if there is diversity, all the benefits that Funke highlighted in her lecture will come to bear. But I have a slightly different view about the international community embracing diversity. It will not happen. I think that if they will not engage or adopt diversity, Africans should also not adopt diversity. I'm making this point because in a particular international arbitration where the Ghanaian party and the foreign party should choose arbitrators, you find the European party listing KC, all of them, KC, no African. So I also nominated SAN. Now, when that goes, there's no transparency within the institution as to who to appoint. Almost invariably, you have them appointing somebody from the European side, but on this occasion, they went with SAN. So you have to be bold in your either drafting arbitration agreement. Don't assign that authority to an institution. Appoint an arbitrator. Give yourself the opportunity to appoint an arbitrator rather than the institution. The institution would normally go for one of their own. We have been on institution for years. You pay dues and pay dues and pay dues. You will never get appointed. That is, if you got that diversity, it will not happen. That is my view.
And just to build on what you said, it's quite interesting if you look at the statistics that some of the institutions put out, the international institutions, for example, the LCIA, you realize that it's the institutions that try to achieve diversity. Council when they are the ones nominating or nominating on behalf of their clients, they do not think about that. When you see an African party, and unfortunately the list of arbitrators that they put together, they do not include Africa. So I think we also have a role to play. As you said, you know, we have to nominate ourselves, and I think that must be done. But thinking about all of these things, the role of African practitioners, law firms, what do you think we can all do? African practitioners, arbitral institutions on the continent, governments, what can we do to really improve this diversity in arbitration?
I agree with Emmanuel that to leave it, 2 points he makes which I agree with, to leave it to others to achieve diversity will not work. Second point I agree with him is that the institutions rather work at achieving diversity. ICC does that, LCI does that. The problem is us. Because in a 3-panel tribunal, the respondent will choose one, the claimant will choose one. If the claimant is not African, most likely he will choose a European or North American. The African party, simply because the non-African has chosen a non-African, wants to show the non-Africans that he knows another non-African and chooses a non-African. The two of them will choose a non-African as the chairman. I was involved in an arbitration recently. Parties were, if you like, 75% Ghanaian because it involved the state and the party. The dispute was about Ghana law. Okay. The Ghanaian party chose a Ghanaian arbitrator. The other 25% or 0.5% Ghanaian chose a non-Ghanaian arbitrator. The two of them chose a non-Ghanaian chairman. So how do you achieve diversity? The problem is us. The problem is us because we don't value our own. I'm not patronizing her, but I've admired Funke since I started arbitration practice. She's held her own. Nobody can convince me that she's not as competent as those old 80, 85, 95, some who sleep during arbitration proceedings, that she's not as qualified as them. I understand your problem. To be 50 and in arbitration, international arbitration, you are a Nino. They are looking for somebody whose tooth is coming out and pushing the... So it is us. Most of the disputes are Africa disputes. And when we're looking for arbitrators, we look beyond our borders. So we can do as Funke and others have done, be visible. But when you have the opportunity, those who will have the opportunity, don't just sit at the table. We all know about Nana Dr. SKB Asante. He gained prominence because he gave a scathing dissenting award in a dispute involving Sri Lanka and another country. That's how he gained prominence. So don't be happy just to be nominated as an arbitrator. Let your work speak for you. Hold the door for others so that in future it can be said of you that it is because the African who sat at the table did not just sit and affirm the African, the Ghanaian law, but gave a decision so that people will know that we are also capable of sitting at the table. What is it? Bringing something to the table. Is that not how they say? Yeah. So we'll bring something to the table.
Ace, I want to turn to you. Mrs. Adekoya mentioned the PNID case in her lecture, and she talked about the insights that Justice Knowles gave, that there was clearly an imbalance in expertise, right, during the arbitration. And we see that for a lot of African states, there's always an imbalance when it comes to negotiating contracts and investment agreements and even managing disputes. In your view, what practical measures can African governments take to strengthen their negotiation skills and terms to avoid, maybe even to avoid unfavorable outcomes in arbitration?
How long do I have? Or how long do you have? TNID is an eye-opener. This starts from negotiation, ladies and gentlemen. Often where you see the dispute started from negotiation. And I think that Funke gave a very good illustration. We are not likely to win the seat battle, especially when the government negotiates and actually it's money coming in. You are not likely to win the seat point because Funke did point out some of the landmines. If you and let me explain. The real thing about seat is that the courts of the seat get to be the ones to handle the procedural matters. And I think that, as you said, if a court can decide that a procedural order is an award and sets the award aside, the transnational entity is not likely to agree to a seat. And especially when you are the one who needs the money, you may. But what we can do is to argue for the venue to be here. The difference is that the arbitration may be seated elsewhere, but you don't have to physically appear there at all. You can conduct the hearings elsewhere. That will bring some in here. But I guess that the confidence will be when the courts understand the principles of arbitration and are not jumping in to try and fix the matters, then everybody will head out to international arbitration. And that's the reality. As long as there's a bilateral investment treaty, even by our own law, the investor gets to choose where the arbitration will be held. So there are things we have to do. So basically, building the capacity of the courts. Let's ask ourselves, are we very confident when we are going before our own judges on arbitration matters? Can I add one more? Especially when it involves the state. Sorry, if you are not, the other party certainly is not. I try to make this short.
Thank you. Emmanuel, do you think that, for example, strengthening or supporting African governments, do you think the national bar associations have a role to play?
The National Bar Association, oh yes. I think that there has to be consistent training for not only lawyers, so you are talking of the Bar Association, but also for policy makers. It's very important because ultimately, if you advise and the policy maker takes a contrary view, then you are not making any headway. So it's capacity building for lawyers in the public sector and the private sector as well. And also you have to add the policy makers. That I think will make the whole process conducive. Yeah, that's what I think.
Mr. Adekoya, just coming back to you, Ace mentioned the issue about having venues on the continent, and you also identified that in your lecture, that even where the seat cannot be in Africa, we can certainly have the venue here. What strategies can African governments adopt to attract more hearings in their country?
I think the local arbitration community within the country needs to have a discussion with the Ministry of Justice to explain what is required. Things such as visa. That's probably the first thing. Visas, how easy is it to get a visa to come into the country? Because if it's going to take 6 months, I doubt whether the way things are going, we're going to see many arbitrations in America.
Yeah.
It's not going to happen.
Yeah.
Even with what's going on in the UK, I'm sure the UK arbitration community will be speaking to the government about the cost of getting visas to come to the UK. So those are the issues. Arbitration community, discuss with government. How easy, what can you do to make sure that it's a good venue? And then arbitration community itself needs to either focus on when I say venue, the hearing places. You don't need to have a purpose-built arbitration center. But I'll give you what happened in Nigeria. The Lagos state government decided that, look, we want to focus on bringing arbitration to Lagos. And we're looking at the West African coast, not just Nigeria. So the Lagos state government built a purpose-built arbitration center, Lagos Court of Arbitration, and handed it over to the arbitration community. Okay, now we've built it, it's yours. Go and run it, go and sort it, go and... That's something else that a government could look at. Okay, we put money into the Ghana Arbitration Center. That's one of the things Kigali has done in terms of the Kigali International Arbitration Center, supporting it in terms of international marketing. So they have a lot of cases, I'm sure more domestic than international. But people talk about arbitration in Africa, here Kigali. I've been to Kigali. I like,
Sure. Yeah.
Now, Kizito, just coming to you, Mrs. Adekoya mentioned, for example, maybe streamlining the visa process and everything, and it just brought to mind the fact that the government has a big role to play in offering maybe economic incentives and policy incentives to make the jurisdiction attractive. What do you think we can do here?
Well, there's a lot we can learn from those who have made it. We have the English to follow. As I said, the legal service sector contributes over 1% to their GDP. Singapore is there. We can look at what they're doing, but it's not rocket science. If you want to attract investment, you must create an enabling environment. Okay, so Funke dropped something. I was hoping the Attorney General, we should position ourselves, Ghana, to be the arbitration hub, at least for the Anglophone countries in West Africa. That's a beginning point.
If Mrs. Adekoya will agree, because I'm thinking like she's looking on her face, Mr. Nigeria.
Yeah, I've turned my back to it. We should position ourselves, or maybe the competition should be between Nigeria and Ghana. If someone is not comfortable in seating or even making Nigeria the venue of his or her arbitration, let's not go to London. Attorney General, tell your people who negotiate the contracts, the arbitration agreements, which has Ghana law as the governing law, that there is no point traveling to the streets of London and Paris for shopping.
There's Oxford Street.
There's Oxford Street in Osu, not far from here. So there's a lot we can do. Make it conducive for people, or even persons who provide support for arbitration services, to position themselves here. But if you don't have the infrastructure, internet infrastructure, of course they will look for some way. If you don't have stability in power generation, they'll look for some way. And sometimes it must be intentional. Make it a policy that we are going to attract investment in arbitration to this part of the world. What do we need? Get out there, speak to the arbitration community, find out how do we turn the tide, and we will get some contribution, because the galamsey, the timber, the cocoa, it will run out.
Yeah. It's interesting. I had a discussion with someone about 3 months ago on having a hearing on the continent, and they were discussing African cities. And Accra was immediately struck out. Although Accra is safe as compared to maybe Johannesburg or other African countries, one of the big issues was the cost of hotel facilities. Hotels are so expensive. If you go to Kenya, you can get a very good hotel for, let's say, $150. In Accra, to stay at a good hotel, you have to really pay through your nose. And it's some of these, little things that can affect having hearings here in Accra. Now, Ace, coming to you, if you look at international best practice, you realize that there are certain things that they put in place. And foreign investors, when they're even thinking about a venue, they want to make sure that some of these international best practices are valued in that particular jurisdiction. In what way do you think policy alignment with international best practices will address perceptions of risk if you were to come to an African venue?
The risks are several, and we would have to identify each of them. I will go back to the attitude of the courts. I mean, I have war stories about African countries and arbitration. A judge sits in an African capital and grants an injunction restraining the arbitrator sitting in the Netherlands from sitting.
It's real, it actually happened.
I'll see the case. All right? There's one where the court granted an anti-arbitration injunction. So restrain the parties from going for arbitration. The next day, we all went to London and did the arbitration. Now, because if we had done the arbitration in Ghana, we would have been in contempt of court.
Yeah.
So if we don't deal with these horror stories, was it recently which Asian country jailed an arbitrator because there was an anti-arbitration injunction? And was it, I don't want to mention the country, but the arbitrator, when these horror stories then discourage people from coming. I'll tell you that when we go to Mauritius in 2014, at the opening dinner, one of the arbitrators who was restrained was at my table, and he made such a joke. I felt so small when he said, "Oh, so will I still be jailed for contempt if I pass through Accra?" Because we went ahead and had held the arbitration. These horror stories get magnified, and so we need to set our house in order. You talked about the hotels, it's important. We also have to think about recording facilities, right? Now, thankfully, AI helps us, but I looked like a Johnny just come when I started at the London Dispute Resolution Center. And the minute I started speaking, my words were showing up in the monitor in front of me. Almost a day was it, right? I hadn't seen some before. At the time in Accra, the judges recorded longhand. And by the time you close and walk down Fleet Street, when you get to your room, the proceedings for the day have been emailed to you in Word, PDF, and they're asking you for review, so they go ahead. The time it takes us to produce records of proceedings, arbitration does not have that time. And so there's a lot to do. And what I'll say is that a lot of the arbitration practitioners quietly know these things, they don't talk about it. But if we begin to build the bridges with policymakers, we can begin to tell them, Michael is here, that look, these are some of the best practices we need to institute. Some may be legislated, some may be just attitude now, some may be provision, etc., etc. Then we can match up. But right now, I'm not sure.
Okay.
Now, Emmanuel, aside from providing fantastic shopping avenues in Africa, what are the top 3 priorities that you think we need to keep in mind if we want to attract arbitration hearings to the continent?
Mike, I think, I think Ace has mentioned infrastructure. It is very key. If you want to, let me mention this. Some time ago, many years ago, when I had a call from London of English law firm who want to have the arbitration hearing at the Ghana Arbitration Center. Then I checked our facilities then, and I knew that that was not going to be possible. All I told them was, call me next week, Wednesday. So when they called, I said, I've checked, we are fully booked. Yes, because I don't want them to come here to disgrace myself. We didn't have the facilities. So you should have the facilities. Yes, now live transcription and all that. And I think I'll mention LACIA, which has that. We are using LACIA and it's very good. Ghana Arbitration Center is picking up. We are also picking. So So they build infrastructure and then also have arbitration practitioners training others to be engaged in knowing the nuances of arbitration, and then government also supporting the arbitration system. Now, when I talk of government, I'm looking at where they have to amend laws to keep up with modern trends. Will be one of the things that one can look at when you have to attract Accra or Ghana, for that matter, as a venue for arbitration. Last point is the negotiation. Still, negotiating the arbitration agreement. There are three things you are looking at: the seat, venue, you are looking at the governing law of the main contract. Are you going to give everything away? At least you must say something. But you will say something only because you know the importance or the relevance of these things. What is the role of the governing law? What's the role of the seat? What's the role of the venue? But if you have no idea and you think of shopping, then
It's London.
It's London.
yeah.
Also circus.
Go forward.
Okay, so my very last question to the panelists, and I would like to hear from each of you. What would success look like for Africa in the international arbitration landscape by, let's say, 2035? And what milestones should the continent aim to achieve along the way? We'll start with Ace and then go along.
Well, success would be if we trust ourselves sufficiently enough to not only appoint Ghanaian or African arbitrators, but for Africans to also appoint African Council. It is interesting that you appear in an arbitration in London, and the state, the government, are represented by European or American lawyers when we are talking about Ghana law. And I think that success will be where we have developed the local capacity enough for our governmental parties to trust us as lawyers, not to go and do some of what we read in PNID. If we do that, then I think that we are looking at success. So appointing Ghanaian Council, or African Council, African arbitrators who have made their name and made their mark and won't mess us all up there, I think that is what success will do. And if our legislative process is quick to catch up with developments in the area, then it would help us. But the last thing escaped me. Talking too much.
Emmanuel?
If that is success, what else should I say? But yeah, I agree entirely with that. I will just do a slight step back of whether we should necessarily at all times use arbitration. That is to say, if you have a dispute, because looking at it, navigating international commercial disputes, we should also be looking at the international settlement agreement resulting from mediation. The Singapore Convention is one thing. So that it is not always the case that when you have a dispute, you are looking at arbitration, and then if you don't have a case, by all means you must go to arbitration. You have to use other means to resolve a dispute. So it is one thing that African countries should look at. Nigeria has done it, they've incorporated it in the new Arbitration and Mediation Act. So we have to look at that one in terms of resolving disputes. Beyond that, I endorse what Ace has said, but in Sussex, if arbitration institutions are handling not only domestic arbitration, but international arbitration, then you can say that we have made a mark from what we know from what has existed previous.
And I'm happy to hear that. I mean, from your experience, a couple of years ago, when you had this experience of a foreign law firm calling to have their arbitration at the center, and you realized you didn't have the infrastructure. I was at the Ghana Arbitration Center, I think a month ago, and we had a hearing there. amazing facilities. There's been a lot of improvements.
Please,
I have to say that a lot of improvements to the extent that the center, headed by Mr. Amofa himself, they actually provided us free lunch.
You did. And then you didn't make a visit from the office.
Yes, Kizito.
Okay, I will look at success in two ways, from the position of counsel and position of arbitrators. 10 years, you said 2035.
35.
10 years is not a long time in arbitration. But I will consider that we are making good strides if governments, because most of these disputes are between states and investor parties. If various governments who are building capacity will insist that even when they have to hire foreign counsel, those foreign counsel will partner with government agencies as counsel. There's a relationship between being counsel and moving on to be an arbitrator. Well, unfortunately, I don't get to be counsel. That's the part I miss very much. He's still being counsel. That's where all the naughtiness is. But there's a relationship between moving from counsel to being an arbitrator. So that when over the years governments have built capacity, these people, whether when they leave government, employment, or whatever, can then be used by this same government because they have developed their capacity as the persons they can appoint onto panels. So for me, success is if within 10 years, I can look and say, okay, last 5 years, government of Ghana has been involved in 10 arbitrations, and all the 10 arbitrations have been conducted by counsel from the Attorney General's Department, either alone or with some other partnership. And that on the other side, I can see, okay, this gentleman or this lady was practicing as counsel some years ago and now has moved on into international arbitration practice. That's what I'll consider as success. As for the legislative framework, that's a cup of tea.
Mrs. Adekoya.
10 years from now, I think there will be more African counsel appearing in international arbitration. I think a lot of them will be working for international law firms. They are poaching young Africans and taking them to New York and Paris and bringing them up. And they'll start appearing 10 years' time. 10 years' time, I think more African countries would have fully resourced their ministries of justice and trained state counsel to also appear, probably with international counsel, in terms of arbitration proceedings. Perspective of the arbitrator. 10 years' time, I think there'll be more Africans being appointed by African parties. But more importantly, I currently sit on 3 disputes where neither party is African. 10 years' time, I think there'll be more Africans sitting in arbitration panels that have nothing to do with Africa.
Thank you. And I think just to wrap it up, throughout the conversation, it's quite clear that the government has an important role to play. And I think also, if arbitration, international arbitration is given some attention, it also helps the government. We have the saying in Ghana where we talk about judgment debts. That is where the government goes for international arbitration and there's a hefty award against the government. And I think that where there is particular attention paid to improving the arbitration ecosystem, the government will also be able to avoid some of these awards with the expertise in-house and with local counsel as well. Thank you so much to our panelists, and we are grateful. Let's put our hands together for them. We are grateful for your time.
I'd like to bring up stage the chairman and founder or co-founder, Mr. Divine Lecha, to bring us some quick closing remarks. Let's welcome with a round of applause. Thank you.
Well, as we say, all too soon, the proceedings have come to its conclusion. The lecture delivered by Mrs. Adekoya has been timely, informative, analytical, direct, deep, and practical. And the discussion that followed has been equally excellent in every way. This is a kind of discussion and intellectual activity that our late brother would have liked to enjoy. And I also thank the Bentsi Enchill family for setting as a background a lot of nostalgia, a lot of remembrance, a lot of memories have been reawakened, but we take it into the future. Thank you very much. The lecture has been stimulating. It took us all over Africa, arbitration issues in Africa. It has been totally well analyzed, and it forms a background, the topic forms a background to the kind of topics that have been selected for this memorial lectures, the series. And they are chosen to reflect our late brother's visions, interests, and his desire to share and to expand the frontiers of knowledge. So I thank all of you for the food of thought and the reflections that are followed. And I think that the gathering here every year of the 200 of us or so who gather here from time to time will serve us better if we take the proceedings forward and put it into practice. And also, I would reiterate the point I made some time back, that we need to publish these lectures. We need to publish them so that we don't just come here, listen to it, and just go and forget, but we need to publish it so they can revisit it and then put it to practice wherever it is necessary. Now, the SWOT analysis by Mrs. Adekoya, as I said, gives a lot of food for thought. The opportunities, the strengths, the weaknesses, and the threats, they have been very well exposed. And those of us who are aspiring, I take note that it is said that in arbitration, 50 years, you are still young. Out of our 70, I think I'm now making it. So please, let us take advantage of the opportunities that have been set before us and see what we can do. Arbitration still remains the best alternative to straight out and out court litigation. And if you handle it well, as has been said, we will grow all aspects of the economy. So thank you very much for coming. Thank you very much for listening. And on this note, I will say until we meet next year.
Thank you. You know, King Agrippa said to Paul, "You nearly converted me to become a Christian. You nearly gave the vote of thanks." But you were to do the closing remarks, but you nearly did it. But since you didn't quite do it, I'll bring Dad Akwesi, who is a partner at the law firm, to finish up with the vote of thanks. Thank you.
Good evening. And Mr. Lecha, thank you for starting the vote of thanks. Distinguished invited guests, ladies and gentlemen, as we bring this year's edition of the KB Memorial Lecture to a close, it is my distinct honor to extend our collective appreciation to all who have made this afternoon, should I say this evening, such a memorable and rewarding occasion. We owe a debt of gratitude to our guest speaker, Mrs. Funke Adekoya, Senior Advocate of Nigeria, for delivering such an outstanding lecture today. Your insights, obviously born out of your rich experience, and of course, the invaluable perspectives and experience of our distinguished panelists, Kizito, Emmanuel, Ace, have enriched our understanding of the existing challenges and opportunities. I believe after this, we can all develop our own roadmaps as to how to overcome these challenges and grab the available opportunities. Notable mention to Nania for very strictly and skillfully moderating the very distinguished panel. To the Honorable Attorney General and Minister for Justice, Honorable Dr. Dominic Aine. I believe he's left, but we still want to, oh right, he's still here, thank you. Thank you very much for honoring our invitation and for your insightful opening remarks. Your remarks have framed our discussions today, and we are very grateful that you made the time. To our chairman for the evening, our own DKD, Mr. Lecha, we thank you for guiding the proceedings in your usual humorous, honest, and relatable manner. We also thank Reverend Stella Bentsi Enchill and the Bentsi Enchill family for the moving words you shared with us and your continued support for these lectures. Behind the scenes, we don't see them, but this lecture has been the product of careful planning and tireless work. So the partners, the staff of Bentsi Enchill deserve our special thanks. The success of today's event is their achievement, and we are grateful. And finally, to all of you, all of us, distinguished guests, your presence here has given meaning to this lecture. By taking part so fully, you honor Kojo's memory, and you reaffirm our belief that what he stood for is still relevant and still stands. On behalf of the organizers and the family, we thank you all once again. We look forward to welcoming you to the next edition of the lecture. Until then, thank you and enjoy the rest of the evening.
Thank you.